Any mention?
Please, Your Lordship. My Lord, I beg to make a mention of item number 37, hearing list. As the conducting counsel is out of station, my Lord.
Lordship,
No objection?
No, my Lord, because last date, Your Lordship, notice has not been served to the pro forma respondent. Pro forma respondent number 3.
Who's for number 3? Who's appearing for him? Sidraman Mukim?
Yes.
I can find.
She's the petitioner. Sidaman is the petitioner, my Lord.
Respondent number 3.
You're appearing?
Yes, Lordship, I have.
Yes,
I'm entering appearance, Lordship.
Today?
Today, for just pro forma respondent number 3, Lordship.
One and 3. You corrected the address?
Yes.
1, you're appearing for 1.
My Lord, for one.
1
Yes,
is whom?
I'm pro forma defendant number 2.
Okay, number 2 is Mr. Walang, number. Who's Catalinda Kirua?
Respondent number 1, my Lord.
Who's representing her?
I'm representing respondent number 1, my Lord.
Oh, it's number 1. Then number 2 is
I'm for 3.
number 3. Okay, and that means notice complete. Yes.
Yes.
Mr. Nongklau is Mr. S. Walang is present. We have number 2 and Mr. Mr. S. Walang is present number 2 and Mr. H. Nongklau is present on behalf of number 3. Stop. Mr. W. Jarua, legal counsel 1 phrase that they might begin after
3 weeks' time, my Lord.
2 weeks, as the arguing counsel is not institution. It's after 2 weeks, yes.
Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 40, Your Lordship. On behalf of the respondent number 3 and 4, Your Lordship.
No
What's
objection.
the matter about?
Cancellation of Pata, Your Lordship.
Cancellation of Pata? Any urgency?
No, my Lord.
2 weeks, yes.
Deeply obliged.
Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 34, Your Lordship.
34.
Yes, Your Lordship. I humbly pray that this matter be taken after a week, Your Lordship.
Where's the petitioner?
We are for the petitioner, Your Lordship.
Bila
Yes, Your
Sama.
Lordship.
You have no objection?
No objection, Your Lordship. After a week, Your Lordship.
After?
A week.
Why? 1 week? Take 2 weeks, don't have to mention again after 1 week. Okay, yes.
Highly obliged, Your Lordship.
Your Lordship, I beg to mention item number 31.
No, I'm not
You're there? No?
No, I'm not there, my Lord. I was.
31, where's 31? Mr. Devnath,
No objection, Your Lordship.
what's the matter about?
Death benefits, Your Lordship. Death benefits. Death benefits.
Then why don't you want to do it? Where's Mr. Gautam?
He is also not available, Your Lordship.
Okay, after 2 weeks. Yes.
Highly obliged.
Hello.
My Lord, I beg to mention item number 23, my Lord. This is the contempt matter, my Lord, where I have also filed a review petition. Yesterday, the matter was listed. The other side sought 2
Review?
weeks' time. Yes, my Lord.
23?
No, 23 Multisha.
23?
Item number 23, my Lord.
Right.
Multisha Kharnayor, my Lord. The other side sought 2 weeks' time to file the response to my applications, my Lord. May I pray, my Lord, that it come out after 3 weeks, my Lord.
CRP number 15. Mix it together with that then.
Take it, my Lord. That is what my prayer was also.
Yes, who's appearing for the other side?
I-
Mr. Sunyota.
Multisha
This matter is adjourned to when?
The other
CRP
case,
15, huh?
yes, my Lord. The other case number, my Lord, I will give it to the court masters.
Multisha
Multisha Kharnayor, my Lord.
is a teacher matter.
Teacher matter, my Lord.
But this is not connected to that. It's 23.
23 is another case.
It's a total different case. You're totally confused.
Oh, I'm sorry, my Lord. Just confirm. Oh, I'm sorry, my Lord. It's 28. In my course list, my assistants have written 23. I'm so sorry, my Lord. It's 28, my Lord.
Assistants.
My Lord,
You have to take the. Oh, 28, yes.
my Lord, 28, my Lord. I'm so sorry, my Lord.
Yes, sir. You're there?
No.
Where's the petitioner? You informed them?
My lord, I could not find them, my lord, today.
You wait, did you inform?
My lord.
Your Lordship, I beg to mention item number 23 and 24. Your Lordship. It will come after 2 weeks, Your Lordship. The conducting counsel is having personal difficulties.
Any urgency?
Urgency in the sense, my lord, these are concurrent finding of facts by both the trial court and the appellate court. And then possession, because we have also sought for
You
eviction.
already surrendered possession. You're not there. You're not possession anymore.
I have no idea.
They are.
They're in possession.
Because we have sought for eviction also.
Execution proceedings have been stayed
No.
after 1 week.
Okay.
Yes, 2020 after 1 week. Mentions made on behalf of the respondents in item 23 and petitioner
Petitioner in
24 for 1 week's adjournment. So, yes, this is a matter of 1 week. Yes.
All right, Your Lordship.
Yes. Make it quick. You were mentioning yes.
I beg to mention item number 25, my lord. This is a joint request, my lord. Pray for 2 weeks' time.
Where join? I see you alone. Yes.
No objection.
2 weeks. Yes. Yes.
Lordship, I beg to mention item number 35, Lordship. 35. It will be after 3 weeks.
What's the problem?
3 weeks, Lordship.
Teacher matter.
Yes, Lordship.
Teacher matter will take 5 minutes.
I'll take instruction on this because because Lordship, the counter has been filed by the government. In the counter, they have annexed some documents, Lordship. So I may withdraw and liberty to file a fresh with.
Mr. S.A. Sheikh, please keep it down. Yes, Mr. S.A. Sheikh, the council petitioner, prays that the matter be adjourned for 2 weeks as to enable to obtain further instructions. Yes. Yes.
Please, Your Lordship, I beg to mention item number 33.
Number?
On behalf of 33. On behalf of A. Karwanlang.
On behalf of whom?
A. Karwanlang.
33?
33, man.
But he's not there in this matter. Capital the price.
Helena Begum.
Oh, 33, okay.
33.
My lord, 1 week after.
1 week, yes.
Similar prayer for 39.
He's
Item 39.
sick again?
I believe. 39.
Okay, 39. 1 week, yes. Your
Your
objection?
Lordship, we have objection.
Objection, okay. We'll take up the matter, yes. 39.
Your Lordship, I beg to mention item number 26. We pray for 2 weeks' time, Your Lordship. The conducting counsel
Your
is out of
objection?
this-
No.
No objection, Lordship.
Don't do matters. If seniors not there, should take advantage. Should take the file and do it. You know? Yes. 2 weeks, yes.
Highly obliged.
Lordship, I beg to mention item number 27. Appearing on behalf of the respondent 1, 2, and 3.
No objections, Your Lordship.
I pray the matter be listed after 3 weeks, Your Lordship.
2 weeks, yes. Please. Due to the anniversary of senior arguing counsel, we have 1, 2, and 3.
Yes, Your Lordship.
Yes.
Supplementary list, item number 1.
Yes, the one said.
Lordship, I'm appearing on behalf of Bhaskar Construction.
There's a caveat, my lord, we have served it.
Take caveat 111/2024. That's the caveat. See the caveat petition. Mr. Wansford is present on behalf of the caveator. Caveat stands as charges. Yes, what's the matter about?
But
You received copies? You see notice?
Yes, Lordship.
But this matter arises from arbitration proceedings, my lord. This is an arbitration under the old act, my lord, 1940 Act. So, award was passed by the arbitrator, my lord.
Has to be an order of the court.
My lord, there were section 30 applications challenging the arbitration award by us, my lord, and they filed under 14 and read with 17, my lord, for making it a rule of the court. My lord, that was filed sometime in the year. The
You ready
award.
the matter, Mr. Want to be ready with the matter, correct?
Yes, sir.
Right.
Now, my lord, what happened, my lord? The matter was pending before the learned trial court, and on
No, when was it filed? Those applications?
those applications were filed in 2003, my lord.
Award is it when?
Award is of 2003, my lord.
2003 award.
2003 award, my lord.
Now we are in 24.
My lord.
21 years.
21 years.
You shouldn't have detained the petition at all. Then they have not been able to get the fruits of the arbitration.
My lord, in the course of execution proceedings, we have paid the money, my lord.
We've already executed the money as well, Your Lordship.
Or money is already received.
Yes, Your Lordship.
Then what have you come now?
Now, what is left, my lord? When the arbitrator section 14, 17 and section 13 applications were clubbed together, my lord, and that was the order was passed in 2018 in our absence, my lord, in the absence of Union of India.
When was the money paid?
Last year, my lord.
Last year.
23.
So what amount of your claims will remain? Interest?
No, Your Lordship, everything is paid.
Then you
Just the...
Is the debt letter, I mean, it's appeal?
It is not, my lord. My lord, I'll just place a few facts, my lord.
Yes. Yes?
Now, my lord, that impugn order was passed in 2018. We filed an appeal under the old Arbitration Act before the district judge, my lord, deputy commissioner, in 2023, my lord. My lord, here what happened, my lord, when the award was made the rule of the court in 2018, my lord, the order was passed in our absence, my lord. Because exactly during that time, what happened, my lord, I was representing the Union of India before the trial court, my lord, and I had submitted my resignation in 2018, my lord. And on that particular day, on 31/7/2018, the matter was heard ex parte, and judgment was reserved, and judgment was pronounced 3 months later, my lord, in October 2018. Department was never informed about passing of that order, my lord. The department came to know about that only when in 2022, after 4 years, my lord, when they filed an execution petition. So when the copy was served to me, my lord, of the execution petition, I informed the department. The department took a decision that it was not within their knowledge, then ex parte order has been passed, and we filed an appeal along with an application for continuation of delay, my lord.
How many days that means?
My lord, otherwise, counting from the date of order, it was coming to...
Knowledge?
1,000.
From the date of knowledge, our cases, my lord, it was about 90 days only, my lord.
Okay.
And now the learned trial court has rejected our application for continuation of delay. My lord, there's two fundamental flaws in the trial court's order, my lord. The learned trial court has proceeded as if it is an application for setting aside the ex parte order. The parameters for setting aside an ex parte order were adopted, my lord, whereas this was an application for continuation of delay. That was the first aspect, my lord. As second aspect, the learned trial court considered the entire period, my lord, whereas our case was that we came to know about the impugn order only after they filed the execution petition, my lord.
22.
22, my lord.
The order was passed 2018.
2018, my lord.
Let's see the order.
My lord. My lord, the order starts from page 119, my lord.
119.
119. The first para says, my lord.
But if discretionary power exercised by a court below us, why should we interfere?
My lord, from the date of knowledge, we learned
Unless
trial.
there's patent illegality writ large in the entire in the order.
My lord,
but
in
if it has been considered and a reasoned order has been passed, why should this?
My lord, in my humble submission, those are the 2 points, my lord, submitted. The learned trial court has proceeded as it is an application for setting aside ex parte order.
But did they consider the delay? Was any reasoning was given there
My
when they
lord.
considered the delay? Would you consider why should we interfere?
My lord, we have come under 36A, my lord. So in my humble submission, the scope will be slightly larger, my lord.
By how many degrees?
My lord, at least 5%.
5 degrees. Yes.
My lord, if I take lordship to page 128, my lord.
Yes.
Para 12, my lord. I'll just read a few lines.
Yes.
The matter was heard on 31/7/2018. However, the order was rendered only on 17/10/2018. It was argued by the learned counsel for the petitioner that he was unaware of the date being fixed on the very next date, that is 31/7/2018, for which reason the counsel failed to appear. It may be pointed out here that our miss case number so-and-so, so-and-so, so-and-so were being tried together. The order sheet of the miss case numbers, however, speaks otherwise, and from the order sheet dated 3718, it is evident that the date was fixed in presence of both the parties, even if the argument of the petitioner is accepted between 31/7/18 and 17/10/18. The petitioner had ample opportunity to file an application seeking leave of the court to be heard. Further, as per the CIS, it has been reflected that on 31/7/18 and subsequent date, the case has been posted for orders, and on 17/10/18, the case was disposed of. Therefore, even if the petitioner failed to note the next date of the case on 37/18, however, the status of the case was available in CIS, which is accessible to the petitioners and their counsel. Further, as per Annexure D filed by the petitioner, which is the letter dated 31 July 2019 from the Garrison Engineer Narangi, Assam, petitioners were diligently following up the case, and the AGE contact of Garrison Engineer Narangi, Assam so and so appears to have attended the hearings on different dates. Therefore, it is surprising that the petitioner has given the next date of hearing in this instant case on 23rd September 2019. There is nothing in the letter that the dates were furnished by the counsel for the petitioner. There is no explanation as to how the petitioner came to know that the instant case was posted on 23rd September 19 when the case was already shown as disposed of in the CIS. Therefore, this court is unable to accept the explanation of the petitioners. My Lord, then para 15, my Lord. Moreover, if the explanation given by the petitioner is to be accepted that they came to know about the decree only when the arbitration execution number so and so was filed, it may be noted that arbitration execution case number 8 was filed by the respondent on 21/12/22. The petitioners entered appearance on 2/2/23. This application was filed on 13/11/2023. But here what has happened, my Lord, because whenever any case is filed before any court, my Lord, as DSG, my Lord, I receive a copy. Now, department may not be aware, most of the time department is not aware about my receiving the copy, my Lord. My Lord, that has been taken into consideration by the trial court because I received a copy, my Lord, so department is aware. My Lord, here what happened, my Lord, 2018 they got a rule of the court, my Lord, from court. They get a decree from the, they wait for 4 years, my Lord, for getting a decree, my Lord. Well, I'll take your Lordship to the decree. Decree was passed in 9/9/2022, my Lord. They themselves wait for decree for 4 years, my Lord. They don't inform the department about 2018 order, my Lord, all these years.
That means it took wrongful advantage of interest of
my Lord,
4 years.
My Lord.
What the total amount come to which you
My Lord, it's about 2.5 crore rupees. About 90% of that we have satisfied, we have deposited in the court.
What was the award amount?
My Lord, here that is, award amount was only about 20 lakh rupees, my Lord. What the arbitrator has done, my Lord, under the old act, there is no clubbing of the capitalization of the interest, my Lord. The learned trial court has allowed capitalization of the interest, my Lord, pendant late interest.
How will you recover it from him now?
Well, the money has been secured. 50% of the money they have been directed to keep in fixed deposit, and that is till December, my Lord.
So on a 20 lakh award, you got 2.5 crores.
2.5 crore.
I think about the interest and everything.
Yes. What do you have to say?
Your Lordship, as per
so now it's
But I pray for admitting the revision, my Lord, and for some interim protection also.
Where's the prayer?
Prayer page 13, my Lord.
So the only thing is that they had a copy of the order of the court making the award order of the court since 2018.
2018, my Lord.
And they kept quiet about it.
They never informed the department, my Lord.
You know, there's no law
But they are taking
we have to inform the department regarding that.
You didn't file execution proceedings immediately.
They waited for 4 years to apply for decree.
Since that the petitioner could take steps, but he never took steps, Your Lordship. That's why
you don't even inform and expect us to take steps.
There's no law, Your Lordship, that we have to inform the department, Your Lordship.
Well, you have to be alive to the. Yes, what do you have to say?
Your Lordship, in fact, Your Lordship, for the
admission of this revision application.
In the impugned order, Your Lordship, it has been inserted, Your Lordship, that order dated 5/7/2018, Your Lordship, if I may read, Your Lordship. 5/7/2018. Impugned order, the first page.
The first page?
The impugned order of this.
Which page is it? 119?
There's no pagination, Your Lordship.
You didn't paginate the.
Malad, in fact, is referring to page 126.
126.
Para 5.
There's no pagination in your application.
But the certified copy we don't paginate, Malad. That's on the top. There's copy certified. But copies are available, Malad, at the end.
126, Your Lordship.
Yes.
Lordship, order dated 5/7/2018. May I read, Your Lordship?
Yes.
CR put up today, Mr. S. R. Sen, learned senior advocate, being assisted by Ms. A.R. Kalwar, appeared for the OP and submitted that he is ready for hearing. Seen only Hazira, filed by Ms. K. Warjri, counsel for the petitioner. Learned senior counsel prays that the instant case may be heard ex parte as matter has been pending since 2003. Later, Ms. K. Warjri, learned counsel for the petitioner, appeared and appraised that the conducting counsel is engaged with matters in Honorable High Court of Meghalaya. Considering the age of the instant case, court finds it appropriate to give one last opportunity to the parties to conduct the hearing on the next date positively, and any of the parties remaining absent on that date, instant case shall be heard ex parte. Your Lordship, it is ordered, you are aware, Your Lordship, that if they miss the date, Your Lordship, hearing will be taken ex parte, Your Lordship.
There are 37 CR put up case adjourned for today, ASCO preoccupied. Then
And the matter is taken up on the very next day, 31/7, the matter is heard ex parte, my lord.
Oh. Okay, on the date fixed 30/7, both of you were ready, were there? Were the petitioner and the...
My lord, it's not reflected in my lord. It only says the matter is adjourned as court is
We
period.
fixed 31/7 on the very next day. That means that at least the parties should be, are they present or not? Was your counsel present that day?
But this is too long, but I will not remember anything. We're going by the record.
You were present on 37. You must have been present since you were there on 31st.
Yes, Your Lordship.
That means when this order was passed, the counsel petitioner was not there.
And on the
When
very
this order was
and on
passed,
31/7/18, my lord, Mr. So and so, advocate so and so, present, none appeared for the period, heard at length, and reserved for orders, my lord. On the very next statement.
Yes. Anything else to say? Yes, sir. We'll examine it. Where's your miss case?
Well, miss case is there, my lord.
Heard Dr. El Muzika led at TSGI, this is also for the petitioner. Issue notice. Mr. Wanswet, no?
Yes, Mr. Wanswet.
Mr. Wanswet is present, sole respondent.
Respondent.
Is present, we have sole respondent through caveat. So no further notice called for. Stop this the matter. Should we call for the other course of court necessary?
In fact, I have annexed all the papers, my lord.
And just list the matter after 3 weeks. Yes. We listed for
admission or
it's all you.
As your lord's pleasure.
Listed after 3 weeks, yes, before the orders, yes. Next in the miss case CRP number 16/2024. This is an application for interim stay of the order dated 4/10/2024, passed by the London Additional to Deputy Commissioner (J) East Khasils, Shillong, in miss case number 113 (T) of 2023. The petitioner in the main revision is aggrieved with the impugn order whereby impugn order is dated
4/10/24.
impugn order dated 4/10 whereby the application for condemnation for preferring an appeal has been rejected. Stop. Dr. Emozi, counsel petitioner, raised that while the matter is under consideration by this court, some limited protection be given to the petitioner. Stop. What have you to say?
Your Lordship, I don't think any interim order we did because award has always been executed. There's no urgency in that matter.
Next one, Mr. Wanswet, on behalf of the respondent, submits that the interim order will be of no use in as much as the award has already been executed and you have already in receipt of 50%.
We have received the entire amount, Your Lordship, but then direction was made that 50% has to be fixed in.
In as much as the respondent has already received the entire awarded amount. However, with the direction that 50% be kept in
Fixed deposit.
fixed deposit
Till December.
till December. So in review the matter, there's no need for Ms. K to dispose before that. Review the matter, no other order to call for this stage. This is the matter for, yes, and then Ms. K is disposed of.
Well, lots of recollects. A few months back, I had come by another revision. This is the same matter, my lord, where the learned trial court is directed for closing down the office of the chief engineer, my lord.
Oh, that's what the award was.
But that is why we are compelled to satisfy the award.
Yeah.
Item number 2.
Number 2 is also same, my lord. Only the miscase number 1 will be 114.
In the miscase under 14. So that's rejected also. Yes. Why there were 2 awards?
My lord, one against section 30 application for challenging the award, my lord. Other way, the 2 awards.
Item number 3.
Three supplements.
Your Lordship, this writ petition was earlier filed before the division bench, and as per direction of the division bench.
Against order of, says, you fight against orders of what?
Yeah, about 18/10/2024, page 23-24. Operative portion.
24.
Yes. Operative portion is there, page 24. In those circumstances, the writ petition from the impugned decision of the customs authority is not maintainable. We dismiss the writ petition, so and so, with the express liberty granted to the petitioner to approach an appropriate jurisdiction in respect of the same cause of action. So here, cause of action, my lord, Annexure 6. Annexure 6 is the tribunal order. Set aside the seizure, an appeal was allowed. Now this
in your favor?
In my favor. So I am and that was accepted by the department also, but 9/1/24 Annexure 7. Now I am the truck owner of 3 truck owners, the same seizure case. I want to release my security deposit based on this order, this Annexure 6.
What is the finding then, Mr. Sir?
5663, Annexure 6.
Yes. What's the finding?
Finding it was set aside both the goods and trucks.
What is the problem now?
Now problem is there. First, initially, tribunal, commissioner confiscated the goods and trucks. I went to tribunal rejected it. Then I went to High Court. High Court has directed tribunal for de novo order. At that time, these truck owners has not come to the High Court because of financial problems. So now tribunal has set aside the order, de novo order 26/6/23 and Annexure 6. Department has accepted it, released the owners, truck owners, one truck owner. He was also one truck owner and owner of goods. Released the security deposit. Now I am the same seizure case. I am the 3 truck owners. I went to tribunal at Annexure 4, miscase. They rejected my prayer.
Where is that?
That is Annexure 8, page 69 to 70.
Why rejected your prayer?
Yes.
Given a similar case, they released the truck?
Yes, my lord. The Annexure 8, 69, page 69, 70. That the applicant has filed the misapplication under rule such and such. It is the contention of the applicant that as per the above order of the tribunal, the respondent has released the goods along with 1 truck. But there are 3 more trucks which were also containing the goods impugned, which have not been released. Therefore, the respondent be directed to release the truck also. Now, heard the Learned Counsel appearing on behalf of the applicant and peruse the records. On perusal of the records, we find that the other 3 trucks were not the subject matter of the order passed by the tribunal dated 26/6/23. Therefore, we do not find any merit in the miscellaneous application.
You mean to say before this court at the point of time only 1 truck came, only 1 owner came?
The owner of the Bittlenet came, my lord.
Only he was also one of the truck also.
Only owner Bittlenet came.
Primarily, Mr. Manik Ranjan Paul was the owner
of the goods, and 1 truck also he was the owner.
So he came before. So ultimately, he succeeded, my lord, on the ground that there is no evidence that these are smuggled Bittlenet. So we have refunded because they were provisionally sold, my lord. So we refunded the amount to Manik Ranjan Paul. Subsequently, the truck owners whose trucks were also seized, they are coming. They are not party in the original proceedings, my lord.
No, no. Initially, we are the party. We have filed before this start.
But
Both
why
truck.
can't be they given the same benefit if if the goods were seized from their trucks only?
My lord, what they did, my lord?
In the tribunal.
My lord, they approached the appellate tribunal directly without first exhausting the remedy before the original court.
No. My lord, he's confusing the court, my lord.
Yes. You'll have enough chance to confuse the court also. Yes. What
And that is why tribunal is held, my lord, that because my lord, because they are not the part of the original proceeding, the appellate court cannot take cognizance of the matter, my lord.
So why didn't you ask for the same order from the
He should approach the department directly by filing an application that please release.
Instead
I am
of
covered
going
by
to
this order.
No, my name is not there. That's why they will not. They are not.
They can do it now also.
No.
Oh, you went straight to Sesat in Kolkata?
Kolkata, yes.
Sestat is appellate court, unless there is an impugned order, my lord.
Or this honorable court may pass an order to tribunal to modify the order based on the subsequent order of the tribunal dated 26/6/23, whereby seizure was set aside.
You go for a tribunal, you place this order, they'll give a similar order. What is there?
Yes,
they can't come. They can't arrive at different finding. Then why if you come before the court again?
No, because tribunal has rejected my miscellaneous.
Doesn't matter. They rejected on the ground that that you were not part of proceedings.
That is.
That means you say this will be you'll be stopped from approaching because of the rejection. You take instruction have up to 1 week, where they let them approach the original tribunal and then.
Original authority, Customs Department,
He
can apply.
Department. We'll pass orders. Yes, heard Mr. N. Dasgupta, the council petitioner, issue notice. Dr. M. Bozika with so-and-so's present. Accept notice on behalf of all of the respondent referendums called for stop. It is next by Mr. N. Dasgupta that the subject matter and issue has already been decided by the tribunal, whereby
dated 26/6/20.
By order dated
26/6/23.
26/6/23, and that when the petitioner had applied for release of his trucks, the same was rejected on the grounds that the petitioner was not part of the original proceedings. So Dr. Mbozika to obtain instructions this after 2 weeks.
Much obliged. Much obliged.
Yes.
Item number 4.
May I please, Lordship? Lordship, this matter with regard to the school managing committee, my lord, with a limited prayer, my lord. The school managing committee, the regular school managing committee was constituted on 30 April 2021, my lord.
30th April 21. It's over now?
Yes, my lord. The managing committee was constituted for a regular period of 3 years term, my lord. Again, thereafter, the same was challenged before this honorable court. During the pendency of this matter, my lord, the term of the previous managing committee was expired. Thereafter, Lordship has passed a direction white order dated, my lord, Annexure 2, my lord. White order dated 13/12/2023 at page 21, direction contained, my lord. In this view of the matter, this writ petition stand closed as being infructuous. However, with a direction that the fresh managing committee be constituted at the earliest in accordance with law. Thereafter, my lord, twice the respondent had attempted to conduct and convey the parent-guardian meeting, but they have
respondent.
My lord, state respondents, my lord.
SDSU.
SDSU, my lord. Yes, my lord.
Yes.
Thereafter, they have postponed and cancelled, my lord.
Why was cancelled?
Due to unavoidable circumstances, they have mentioned that only the state respondent could have explained, my lord. In the order, the postponed or cancellation order, my lord. I come before your lordship with a limited prayer to direct the respondent authorities to.
You take notice first.
Yes,
yes,
your lordship. Yes,
I'll come.
Council
petitioner. MS Saji is present.
1, 2, 3.
Except on behalf of respondent.
My private respondents are there. Yes. Principal is the party, my lord.
Yes.
4, my lord.
No notice to issue to the private respondent presently.
My lord, in the meantime, my lord, no
notice to issue presently. learned GA to cover instructions.
My lord, in the meantime, no ad hoc committee or special committee, my lord. Because, my lord, in the my lord, my writ become infructuous, my lord. If
why the moment this
no, my lord,
will file immediately constitute
no,
the
no, my lord, kindly appreciate, my lord. If in during the
it is provided that any further what do you call it?
My lord, ad hoc or special committee shall not be constituted without conducting the parent guardian meeting, my lord. That is the only
Your Lordship,
limit.
I may be allowed 2 weeks time to come up with proper instruction, Your Lordship. Because I am not aware of the case.
My lord, only limited prayer, my lord. During this time, my lord, if they constitute any issue, any order, my lord, my writ become infructuous. My lord, writ become infructuous, my lord. Kindly appreciate, my lord.
Yes. 10 days for notice.
My lord.
Yeah.
Item number 5.
Deeply obliged, my lord.
What is this?
May it please, Lordship. Lordship, I pray that matter may come at the end of the board.
Start. What's the matter about?
This is regarding the appointment of headmistress, Your Lordship.
Regarding the
appointment of headmistress, Your Lordship.
headmastership.
Headmistress, Your Lordship.
Headmistressship. Who are you?
Lordship, I'm the headmistress earlier, Your
Doesn't
Lordship.
headmistress.
Lordship.
Yes.
My lord, this order is also under challenge, my lord, before this honourable court in the division bench. My lord, this is the second round of litigation, my lord. In the first round of litigation, the petitioner had approached this honourable court, my lord. Thereafter, my lord, they got certain orders in their favour, my lord. Now, pursuant to that, my lord, what had happened, my lord, in that case, my lord, the managing committee was never made a party, my lord. So, my lord, after having realized the managing committee, when they came to know about the decision, my lord, they have approached this honourable court, my lord, which is listed before lordships, my lord. It was listed yesterday, Tilapara, my lord. So, my lord, that order is also under challenge before this honourable court, my lord.
Which order? This order is being under challenge here.
Yes, my lord. Order is.
Put it together with the matter of division bench. Or wait outcome of the division bench matter.
Kindly let the matter come at the bottom of the board, Your Lordship.
He's there. He knows all the facts of the case.
The brief is. We don't have the brief, Your Lordship.
You don't have the brief? Okay. It's a matter tomorrow. Yeah.
Let it come up tomorrow.
You get instruction, huh?
At the
End of the board. Okay, end of the board.
Item number 6.
Yes, yes. This matter has been listed today because at the time of while I was sitting last weekend to prepare the order, certain there's been some anomaly in the numbering of the wills applications. Now, first 2 applications were filed by the what do you call it? By the respondent. That's 4 and 5 and 6, correct? Now 8, 9, 10 was filed by Mr. Jyotirendro's client for recalling replacement statement, correct? Yes. That is 8, 9, and 10. Now the respondent to these applications had filed 13, 14, 15 replies, which were listed as missed case. Yes, anomaly is that they should not be listed as missed cases. They were just replies to 8, 9, and 10. That's all. So I want to strike off this 13, 14, 15. Then we'll pass orders. That's all. Just to bring to your knowledge. Yes. Yes. Due to certain anomaly, whereby missed case number 13, 14, 15 have been registered, which actually contain replies to the missed case 8, 9, and 10. Of the 3 missed cases are only struck off from the records and are disposed of, and the affidavit filed in the said missed cases shall be placed in missed case number 8, 9, and 10. Yes. We won't fix dates because we pass order. Yes. Yes.
Daily list, item number 1.
Lordship, in this matter, notice has been served to all the respondents.
All of them?
I'm entering appearance on behalf of respondent number 1, Lordship.
Number 2 is already there.
Yes.
3?
3 appeared in earlier, Lordship.
Appeared earlier, who?
Jarwa.
Who is the 1 and 3? Correct address you'll supply?
Yes, my lord.
Jarwa meaning?
W. Jarwa. He appeared for respondent number 3.
One year appearing, Mr. Noklau.
Right, yes.
2, Orianda Kharkumar, Mr. Walang year appearing.
Yes.
And Catalinda, then the other case contempt.
Yes, my lord.
And where's the Jarwa now?
These are connected, my lord.
Where's that, Mr. Jarwa? Take down interference today.
Yes, Lord.
Mr. H. Noklau has an interference today on behalf of respondent number 1. Though the counsel from number 3 is not present, Mr. Jarwa had entered was present earlier on behalf of the respondent. According to this matter, you need the records.
The record has been called, my lord, in the other matter.
Then we listen for hearing?
Yes, ma'am. All right. Tag together item number 37. Item number 37.
Where were you? Item number 37, yes. Record the presence of Jarwa for 3, 1, 2, 3.
I will find my power today.
Good day. Number 1, Mr. Noklau, interference today. Number 2, Mr. Walang. And number 3, you do your right. Yes.
Item number 2.
Right.
Please, Your Lordship. Lordship, bottom of the board. Bottom of the board, Your Lordship. Bottom of the board.
What's the matter about today? Today's what's it for?
For reply to the 711 application, Your Lordship. We have to reply to the 711 application, Your Lordship.
On the 711 application, because I have already concluded my arguments, Mr. Paul
We have
has
to reply,
argue.
Your Lordship.
End of the board. Yes, should
May I
have
have
been
it,
here.
Lords?
Why, he's in other
May
court?
I have it?
Or he's at home?
Lordship.
He's in another courtroom, he's at home.
No, Lordship, there's some medical emergency he has to attend, Lordship.
Then he put an adjournment application.
Lords,
There's
may I
no
have
point.
it then up? Yes, ma'am.
If he doesn't come, he put an adjournment application. Yes.
Item number 3.
Well, the hearing of the appeal has been expedited and it is coming up on 26th of this month. So if your lordship kindly...
26th of this month?
Yes. So if your lordship kindly defers it by 4 weeks.
You can file fresh contempt if the writ appeal is dismissed. Okay. Mr. Datta has apprised the court that the writ appeal
It has been posted for hearing on 26th.
He prays that this incident matter is thereafter. Accordingly, this is a matter after 26th November to avoid any outcome.
After 4 weeks, 10th of December, if your lordship.
Okay, 10th of December. 10th December, very difficult date.
Date will come.
Yes.
You'll have traffic jam come this long.
4.
Please, Lordship, as per the last order dated, I have filed a rejoinder, Lordship. This later matter may be posted for hearing.
What's the matter about?
This is regarding the non-payment of salaries.
You paid salary now?
Yes,
From where? GGDC?
Not GGDC, it's from Bagmara Municipal Board.
Bagmara Municipal Board, Your Lordship.
They have paid.
Sad story. You let it remain in orders and dispose of, or you want to go for hearing?
Yesterday
They have paid some portion. I mean, it's like not entirely. Now the remaining is 23 months that is remaining.
They're helpless. Even if you take a stick and beat them, like you won't get a salary. What are you going to do?
No,
You take
actually,
you take CEO and beat him with a stick. Also, he can't pay a salary.
Actually, my lord, what happened is because there are some grant aid, means from they're getting from the state. As per the instruction from the client, the petitioner.
Grant it only for salary? Or grant
Yes,
it for doing
yes,
other
that is
municipal
only
activities?
actually made for
Only
salary.
salary?
Rest of the money they're supposed to generate and get it, but as according to the petitioner, they are not utilizing properly.
How much
There's
money
some
generate
must
in revenue, Bamara Municipal Board? You won't have any idea. Looking at the papers won't help. It's just a question.
In their affidavit, Lordship of the Municipal Board, kindly turn to page number 9.
What did they say?
The state has recently sanctioned an amount of rupees 20 crores.
When?
For the year 2024-25.
When?
For
When?
letter dated 5/9/2024, September 2024.
You ready the matter today?
Your Lordship, yesterday only
Lordship,
they...
I have not received the rejoinder yet.
You give rejoinder also
No,
to the other
actually,
council?
yesterday we went, we served in the office. The office people they called her, but she didn't pick up the phone.
Okay, next time I'll go personally. You.
No, actually, what happened?
Just a matter of the 1 week, yes, before the orders.
Item number 5.
You give copy.
You
This is 4 of next week, yes. Yes.
My lord, the rejoinder is ready. My lord, I humbly pray we be granted
How many
time.
times you prayed?
My lord, this is the second time. My lord, it will be filed in the course of the day, my lord.
Yes, Mr. Missile submits that the joint plan court the day on this matter. When? For hearing?
Maybe
What's
posted
the matter about?
My lord, is unpaid
regarding
dues, my lord.
bill, my lord.
Unpaid
Disputed
bills,
bill.
Deeply obliged, my lord.
Obliged, my lord.
6.
May it please your Lordship.
Joined us filed?
No, my lord. My lord, here in this case, no, we are waiting for one report, which the state has filed in their affidavit in opposition, in order to get the clear view of that letter. So we are waiting for that one report from the parties.
How much further time you want? 2 weeks further time. Enough? Yes. Allowed to the President for the joint list thereafter.
15. 15.
You hurt yourself?
Sorry, I apologize, my lord.
No, no. It's like a movie sound effect, yes. Yes.
They have not filed.
My lord, I'm praying for another 1 week time, my lord, for filing the affidavit, my lord.
Similar prayer, Your Lordship, just a week's time, Your Lordship.
Miss MS Island 1, 2, 3, and what about number 4? Where's the Jarwa?
You won't be filing as well, because it will be reporting the order.
Okay, MS Island 1, 2, 3, Adata, 5, 3, 4, allowed. Your matter's being called out.
Apologies, my lord.
At least be here when your matter's called out. Miss Island 1, 4, 2, 3, and Adata for 5. Pray and allowed for the 2 weeks time for affidavit, yes. So don't name the councils at Lasangui and Jarwa for the other councils.
16.
Affidavit.
Yes, Your Lordship. Lordship, I pray for further 2 weeks' time, Lordship.
When was this filed?
Lordship, 7/8/24.
Okay, for the 2 weeks time.
17.
Yes.
Your Lordship, in this matter as well, Lordship, I pray for further 2 weeks' time, Lordship.
Yes. What's the matter about?
My lord, it's a cancellation of appointment, my lord.
Which post?
My lord, he was declared unfit for service, my lord. That's all, my lord. The respondents are to file the affidavit, my lord.
Further 2 weeks time allowed. Responsible affidavit. This thereafter. Yes.
Much,
18.
Yes, ma'am.
Lord, I pray for 2 weeks' time to file my affidavit.
When is the matter filed?
It was filed on.
This is the third occasion, man. After
What
the
instructions on that?
I've got additional instruction. I've got.
What's the matter about?
For the appointment of the sericulture.
September. What's the matter about?
Appointment, Your Lordship.
To which post?
Sericulture demonstrator.
File affidavit. Thereafter.
19.
Your Lordship, the respondents are supposed to file their affidavits, Your Lordship, in this matter.
For 2 weeks' time to file my.
Similar prayer, Your Lordship. Similar prayer, Your Lordship.
What's the matter about?
This is a Nokmaship dispute, Your Lordship.
Okay, further 2 weeks' time allowed to respond for affidavits. This thereafter also.
20.
May it please, Your Lordship.
May it please, Your Lordship. I'm praying for 2 weeks' time, Your Lordship, to file affidavit.
Why you're praying? You already said you're going to file affidavit within 2 weeks.
Your Lordship, due to the ongoing situation in the university, Your
New
Lordship.
situation is lockdown. Oh, you got money, 11 lakhs.
Yes, Your Lordship, during the pendency.
How much more pending?
The total is around 19 lakhs, more or less 19 lakhs.
19 lakhs more. Yes, MS S. Shalam prays funds allowed for a 2 weeks' time. File affidavit. Yes. Just after sunset.
21.
The respondents taken steps. Anyone appearing for them?
Yes, Lordship. For 4 and 5.
Have you service complete?
Yes, Lordship.
This is pension matter.
Lordship, here pension was stopped, Lordship, because of not having.
Counter claim.
No, Lordship, no. Not having joint notification.
Or your State Bank of India? Okay, fine.
Yes, State Bank and that Treasury.
You're filing affidavit.
I'll file my affidavit.
When?
2 weeks' time.
Mr. Thar, right? This under appearance on behalf of 4 and 5. That service complete. You're filing affidavit also? You filed it? Yes, sir. It's going to complete. Stop like Mr. A. Moomin. Also, Mr. Thar, pray for allowed 2 weeks' time to file affidavit. This thereafter also.
22.
Obliged.
Last one.
Please, Lordship. Lordship, we have taken steps with regard to respondent 5, Lordship. And the status report says that they have already been delivered, Lordship.
Yes, received back. Officer indicates that respondent 5 has since been served, but no appearance has been made on their behalf today. Yes?
No time for 1 to 4. So I require some time for filing.
Mr. Kimi Varksai, Leonard GA, on response 1 to 4. Praise that we allowed 2 weeks time for affidavit. Prayers allowed list after 2 weeks for affidavit by 1 to 4 for appearance of respondent number 5. What about number 6 and 7?
Lordship, respondent number 5.
Took steps on behalf of all respondents.
Steps was taken only on respect of respondent 5, Lordship. There are only 5 respondents, Lordship.
What about 6 and 7 then?
6 and 7 are not, Lordship. Respondents, there are only 5 respondents.
Oh, okay, sorry, yes. Oh, yes. Okay. Come now.
Hearing. Supplementary list. Item 15.
Yes.
This is that matter that has been heard by your lordships yesterday. The written argument is ready, my lords. Just a couple of corrections. We'll file it with the court master and the court officer.
Next matter.
Obliged.
Second call, item number 5. Supplementary list.
Wait, please, my lords.
But I was just informed by the GA that it's the same order under challenge before in the writ appeal.
My lords, order is under challenge. That's not what we are aggrieved by. I have acknowledged the fact that some appeal has been filed by the managing committee. That's not the issue. What has really happened here is, my lords, after the orders had been passed by this honorable court, as rightly is to be done, my lords, the state had requested the joint director, my lords, to comply with the judgment of this court. Because the appeal is still pending, my lords, it's not been admitted as yet. There is a delay. Now, initially, my lords, an order has been passed reinstating the petitioner back to her original position.
So you would, I mean.
Myself, my lords. Subsequently, my lords, on the basis of some other letter, now they have again undone that order which had been passed by them, my lords, which is what has prompted us to come before your lordships. If I may just very quickly take your lordships, my lords. If I may take your lordships to Annexure 9 first, my lords, at page 41.
Yes.
Now, this is after the judgment has been delivered by this honorable court. This is a letter, my lords. The typed copy is at page 42.
Yes.
Whereas this is from the State Education Mission, State Project Director, my lords. He writes to the District Mission Coordinator as well as the Joint Director Mission Coordinator.
Now this order is reinstated on 7th October
My lords,
2024.
lordships.
Then what happened?
After that, my lords, there is another letter which comes on 22nd October 2024.
Yes.
And well, this is very interesting. It says, with reference to the subject cited above, I am to enclose herewith letter number so-and-so from so-and-so advocate so-and-so, along with copy of the aforesaid miscase and copy of writ appeal challenging the judgment and order dated so-and-so by the single bench of so-and-so, so-and-so versus so. The content of the matter is self-explanatory and may be taken note of it to act promptly and avoid any complications. Till here, my lords, there is no problem. Thereafter, my lords, the impugned order comes, and if your lordships kindly have a look at page 45. With reference to the so-and-so, my lords, this is the typed copy, I'm sorry, at page 46. It says, my lords, with reference to the subject cited above, I am to enclose herewith number so-and-so, along with all enclosures received from the state so-and-so. The content of the matter is self-explanatory. You are therefore requested to maintain status quo and revoke all orders passed on matters as instructed by this office number so-and-so until further notice. The mere fact of filing an appeal, my lords, cannot preempt somebody to, my lords, pass this kind of an order. Besides, my lords, this order being illegal, it is absolutely contemptuous.
Now, after the order 22nd October was passed,
my lords.
Oh, sorry, 7th October, you took charge as head teacher.
Yes, my lords.
What is the situation?
My lords, that I am not sure, my lord. My lord, here, my lord, will kindly appreciate. My lord, if any order is to be passed, my lord, that is why it's very necessary that we file an affidavit in this regard, my lord. My lord, if any order is to be passed, it is to be passed by the managing committee, my lord. Even order for reinstatement is to be passed by the managing committee, my lord.
Matters, Mr. Paul, because other matters pending before the division bench.
No, my lords,
I'm one of the, I'm part of that bench.
My lords.
That's the thing. So you have to examine that in.
No, my lords, I'm on a different issue. My lords, can the appeal is filed by the managing committee? My learned friend, my lords, communicates the pendency of an appeal before the authorities. Rightly so, appeal is filed along with an application seeking condonation of delay. And, my lords, application seeking leave, because they were not parties to these proceedings. Now,
you were the petitioner initially.
I am the writ petitioner.
But you did not make the managing committee party.
At that point of time, the managing committee was not existent, my lords. Now, what basically happens is, my lords, can the filing of an appeal, my lords, cause somebody to recall or revoke an order which is already passed? Had it not been passed, my lords, correct.
No, right, but then have you taken charge?
Well, if I have not taken charge, my lords, where was the reason for them to revoke that order?
My lord, in my respectful submission, my lord, I don't think he's taken charge. She's taken charge, my lord. To my knowledge, my lord, she is not taken charge.
I am the parent division bench. You are appearing there also?
I am there for the government, my lord.
Okay.
State is
My
not.
lord, will kindly
Lords,
appreciate
what I
another
cannot
aspect.
understand is why is the state taking these kind of a flip-flop stand?
No.
Because of the simple reason state is not even the appellant.
My lord will kindly understand.
No, Mr. Paul, you have to understand their position. Look at them from their side also. They don't want to create any complications.
My lords, they are creating the complications by passing these orders.
Right. Unwittingly, it might have created, but to avoid complications, okay, fine. This appeal is pending, so, tread softly. That's all. The thing is that they've gone ahead and recalled that order. So, actually,
my lord,
whatever it is, you should have...
my lord, even order for reinstatement, my lord, has to come from the managing committee, my lord, not from the government. My lord, apart from that, my lord, if I am allowed to narrate a brief history of this case, my lord, what had happened, my lord, is that originally, my lord, the post of the head teacher was being held by the brother of the petitioner. The father of the petitioner was the secretary of the managing committee. My lord, the moment the brother got some other job, my lord, he left the post. Behind the back, my lord, without any advertisement, my lord, this petitioner was taken in as the head teacher, straight away, my lord, directly. Now, my lord, this fact...
But head teacher, they has to be advertised, no?
My lord, otherwise, my lord...
I don't understand whose case is my learned friend espousing.
No, my lord, let me... My lord, because these stands were taken by us in the original
That has
petition
failed.
also.
You have not gone up in appeal. If
My
the
lord,
state has not gone up in appeal, can my learned friend now make these statements
my
before
lord,
this
it is
court?
before this honorable court.
Let him submit, yeah.
It's not a fact that there is no appeal lying at all. Some appeal is filed before this honorable court.
Where you are a respondent.
Yes, nevertheless, my lord. But my lord, if this appeal, the appeal which is filed is addressed, my issue may also be get addressed, my lord. Nevertheless,
I'll
my lord,
piggyback.
my lord, what had happened, my lord, thereafter, my lord, the private respondent, because this was our stand, my lord, in the previous writ petition, the private respondent had continuously objected, but my lord, those objections were never taken into consideration. Then thereafter, my lord, once that managing committee, because even the managing committee was managed by the petitioner's whole family. So subsequently, my lord,
don't take on.
That's a long
only
history.
materials on record.
My lords, I would only pray, my lords, at this stage, let them file an affidavit, my lords.
Yes, we'll
My
file
lords,
an affidavit.
No, my lords, I would only pray for a small interim order, my lords. This order cannot be passed. In view of, my lords, what has happened, otherwise anybody would
My
prefer
lord,
an
whether
appeal.
she has taken charge also, I'll have to take instructions, my lord.
Issue notice. Mr. K.P. Bhattacharjee is present on behalf of the respondents 1 to 5 to present offer. Issue to 6 and 7. I don't want to be caught in a funny position also in sitting in the DVA.
My lords, I quite understand.
Whether we have to pass orders like where the orders being assailed,
My lords, if I may,
and where the orders you're deriving benefit from.
My
So I
lords,
don't want that. You know, that
my lords,
situation.
my lords, if I may,
yes.
Assuming, my lords, that the impugned order in this writ petition was not to be passed, my lords, any orders passed by the division bench would automatically govern the fact of my service.
Right. That is what is coming.
Now, what my, if I may, my lords, with all due respect, what my learned friend seems to be arguing, my lords, is, my lords,
respondent. That's besides the point. Yes. After that, so it was reported. There's been this court has been apprised that in connection with the same subject matter issue, a writ appeal is pending before this court, which is pending consideration.
my lords, it's not pending consideration. Leave has not been granted.
Leave has been granted, yes. Okay.
Not granted as yet.
Okay, it's pending consideration on the leave to appeal filed by the respondent number 6.
6.
Yes. Next paragraph. Mr. K. Paul submits that pursuant to the order passed by this court in WPC number 390/2016, the petitioner by order dated 7/10/2024 had been reinstated as head teacher, which however has been revoked by another order dated 23/10/2024. 24, yes. Mr. Came to obtain instructions on the matter list after 1 week.
My lords, I am just one clarification, my lords, my learned friends pointed out. The impugned order, my lords, does not revoke the order. It's a direction to revoke the order. If I may just take your lordships back to that order, my lords.
That order of 23rd?
My lords, 23rd. Which is why I say let status quo be maintained, my lords. You are therefore requested to maintain status quo and revoke. So there is no order of revocation as on today.
No,
So then
and revoke all orders passed in the matter.
My lords, it is a direction by the district mission coordinator to the joint mission director. Because the order, my lords, under the order of 10th.
Order 22nd says.
My lord, petition is premature, my lord.
May I just finish?
That is
I
so.
can understand where your allegiances lie, but may I just finish? my lords, may I just take your lordships to Annexure 10, page 43. The order of reinstatement, my lords, is passed by the joint director, district mission coordinator.
Yes.
Now, this order of the 23rd, my lords, is passed by the district mission coordinator directing the joint district mission coordinator to pass an order of revocation. So that's not been done as yet.
So, my lord, this petition is premature, if that is the case.
It is not premature, there's a direction. Let status quo be maintained as on today, my lords.
Have been reinstated. Yes. Which however by letter dated
23rd 10.
23/10 is.
So there is a direction only, my lord.
But with 2010, it says revoke here.
No.
Directed
You are
one,
therefore requested to maintain status quo and revoke, my lords. It's a direction to revoke it.
Which is wherever by a subsequent letter dated 23/10 issued by the respondent number. Respondent number.
Well, just
joined by number 4.
Respondent number 3, my lords.
Sought to be revoked.
R3, my lords.
Yes, by no joint mission is 4.
4 and
yes, which sought to be revoked. Stop. He praised that in the interim that will be maintained. Next paragraph. I've heard legal counsel of the parties and examined the materials on record. It is undisputed. It is not disputed that a writ appeal is pending consideration, though at the initial stage on the application for leave to appeal before the division bench of this court, and that the subject matter issue is the same. Stop. The petitioner appears on apprehension after being instated that due to the order dated 23rd, she would be removed from the post again. Appears to be unfounded, as no formal orders have yet to issue. However, in the interest of justice, the status quo be maintained till the next date.
Balance.
Mr. Kivarji to come out instructions within 10 days. Yes.
10 days. I'll be obliged.
Obliged.
Daily list item number 2, second call.
Ali Akbar. This is the election matter where my learned friend had filed a 711 millets, and he had completed his side of the argument. Millets, I am required to reply. This will take a little bit of time, millets, whether your lordships would have it now or at the end of the board.
We'll have the end of the board then. Yes. But provided you're ready with the matter.
I'm sorry, millets.
Provided you're ready with the matter.
I am, millets. Because it's only on law issues that I have to respond. Obliged.
This is the contempt matter, my lord, where I was seeking time. I have been informed by one of the junior associates of the petitioner, my lord. I think he's having some personal difficulties.
28?
28, the contempt matter.
Where there was some objection?
No, there was an objection. There was a confusion. I mentioned 23 instead of 28, my lord.
Okay. Where's the petitioner?
I have been informed by one of his juniors, my lord. It's not. He is having some personal difficulties too.
Mr. Molong.
Molong and his junior, my lord, the one who often appears.
Okay, this none appears on behalf of the petitioner. Is the matter for 2 weeks. Yes.
Let it be 3 weeks, my lord, because the other one, my lord, obliged.
Your review, I don't know where it'll go, but anyway.
My lord, obliged.
Yes.
29.
I have to remove for the petitioner, Milord.
Yes. Same matter is completed today. Yes.
My lord.
Yes.
My lord, this is a matter relating to the transport subsidy, Milord.
Yes.
Where the claim was first sanctioned to the petitioner, and thereafter the the petitioner again wrote a letter to the authorities that why the claim was not sanctioned. And the district and industry center regularly is writing letters to the government of India for seeking for clarification, and the said clarification was not issued to the authorities as yet, and because of that, the claim is pending.
Where Dr. Mozika? You're the only because the state supporting the case of petitioner. Dr. Sarah will have to take it after some time because Dr. Mozika is not available now. It's on legs in court number 1.
My lord, as you lordship.
After some time, we'll take it after 1 week.
As you lordship, my lord,
Yes, just make sure. We'll take a fixed date and we finish it off, please. And this matter has been hanging fire for too long.
My lord, 21st November.
21st November.
My lord.
Yes. As the matter, as the London DSG is not available, this matter is a fixed item on 21st November.
30. Much obliged, lordship. 30.
My lord.
Where's the additional affidavit?
My lord, I could not, my lord, due to...
Why?
Due to Chhath festival.
Due to?
Due to the festival.
What, Chhath Puja or Diwali?
Chhath Puja. So, a week's. It will be on the board.
Mr. Archa prays for further 1 week's time to file the additional affidavit, which was allowed by order dated 16/10/2024. This is matter after a week.
Hello.
Obliged, your lordship. 32.
This matter, we are challenging the blacklisting order.
Blacklisting?
My lord. From our side, really, Dr. Mozika is...
Lordship.
You can start. How long will it take?
I can start if they are ready to
He'll come back, I suppose. We can't be incapacitated this way. As we'll take up that election matter. What is the matter about? Why blacklisting, on what ground?
My lord,
were you given adequate opportunity to represent?
My lord,
before
according to me,
blacklisted?
the show cause notices issued to me was not relating to blacklisting, my lord. Lordship, you kindly see the blacklisting order, page number 110. My lord, Annexure 22. I'm challenging this, my lord. My lord, it is to inform you that you have participated in the tender of above 3 works, wherein you have quoted the lowest rate. However, moreover, one work, my lord. It's before issuing the acceptance order. I'm sorry, man. The page number 109, 109, sorry. I'm sorry. Order, my lord, 27 June. As approved by the competent authority, your firm, MS Capital Such is hereby debarred from participating in tenders of PSF, Meghalaya Front, and other command headquarters for a period of 3 years due to poor performance, inordinate delay, and lack of interest in the execution of the work. Now he has communicated this to my lord. Me, number 1 is me. Number 2, my lord, PWD building, director ICAR, director NIPA, my lord. Headquarter chief engineer, my lord. Yes, I may agree with this, my lord. If they are debarring me from the PSA work, my lord, that is one issue. But here he is circulating all, and because of this impugned order, all my other works are also.
Now, what is the grounds of challenge of the debarment?
Now, may I come to? Sure, my lord. The Lordship, kindly come to page number 22. Annexure 1, the contract paper. The estimated cost of the contract is, my lord, for digging a deep well in Umpling PSA, my lord. It's 9,82,000, my lord. Now, pursuant to this, my lord, the acceptance also.
So where's the notice, Mr. Where's the notice for?
My lord, show cause. I'll come straight away to the show cause.
Yes.
My lord. Now, my lord, we come to page number 89. 89. First show cause notice, my lord. 10 January, my lord.
One second. Page?
Page number 89. 89. Now it says, whereas it appears to the undersigned that by reason of your wrongful delay, suspension of work entrusted to you under the agreement referred to above has not been started yet, as the stipulated date of completion has already been lapsed, and even after a considerable period, it is very difficult to assume that you will complete the above cited work as soon as possible. Neither you have reported nor any information have been received on your behalf. This shows your lack of interest in execution of the subject work, mismanagement and poor performance, and in case you are having any difficulty in execution, same may be brought to the notice of the undersigned so that necessary action can be taken accordingly as per terms and conditions of the agreement. Therefore, in exercise of the powers conferred on me by the aforesaid agreement, for and on behalf of the President of India, hereby give you notice to show cause within 15 days to my satisfaction why an action under clause 3A and B of the above agreement will not be taken against you on account of the breach of contract on your part. Please note that in case no cause is shown by you within the stipulated period of or the cause shown
Where's clause 3, let's see?
My lord.
Clause 3, where's clause 3?
My lord, that page number 43. Of the writ petition, my lord.
Page number 43.
Well, page 43.
Yes.
My lord, may I come to 43, my lord. 3 consequences of breach, my lord. Without prejudice to any right that may be available to the principal owner, these are the PSF, my lord, under law, or the contract or is established policies and laid down procedure, the principal owner shall have the following rights in case of breach of this integrity backed by the bidders, contractors, and the bidder contractors accepts and undertakes to respect and uphold the principal or owner's absolute right. But it is important. If the bidders, contractors, either before award or during execution of the contract has committed a transgression through a violation of Article 2 above or in any other form, such as to put his reliability and credibility in question, the principal owner, after giving 14 days notice to the contractor, shall have powers to disqualify the bidders, contractors from the tender process, or terminate or determine the contract if already executed or executes. The bidder or contractor shall exclude the bidder or contractor from future contract award process. The imposition and duration of the exclusion will be determined by the severity of transgression and determined by the principal owner.
Under clause 3.1, that means that you should notice.
My lord. So this, my lord, if I understand properly, under these 2 clauses, they can take 3 actions. One is they can exclude me, my lord, depart me from the contract. Number 1, disqualify me, and if I execute, then they can determine or cancel my contract. Third is, my lord, they can depart me in the future, then the activities, my lord. Now, pursuant to this, they have issued this first show cause notice, which I read out page number 89, my lord. And immediately, my lord, I have given reply in page 90. My reply was given, my lord. Reference to your show cause notice dated such, I would like to inform you that after continuous discussion on telephonically and through message to executive engineer, I was not handed over the site, stating reason that physical survey has not yet done by the Central Groundwater Board and also official persons, and JE Mukhi told me to license with the Central Water Board, handing over to me reference letter dated such, which is enclosed for your reference. And for the reason I was not hand over the site, and in return I'm getting this show cause notice, which is very sad for us. But in any way, I request you to early hand it over the site to execute the work. But when they issue first show cause notice, site was not yet handed over to me. And thereafter, my lord, page number 91, they have issued second show cause notice. But the first show cause notice, they said they quoted clause 3, my lord, which action they are going to take against me, they did not specify, but they quoted the clause. Second show cause notice, page 91, similar ground, my lord. Similar one. And before expiry of this was issued on, my lord, 6 February 23. And before expiry of this, my lord, 15 days, the same authority has issued another letter, page number 92.
1 second. The first show cause was on which date?
10 January.
10 January.
My lord.
10/1/23. Well, the reply is?
My reply is 12 January. Immediately I reply.
12/1/23. Second show cause 6/2.
Right,
6/2/23. That is after, yes. In 1 month. Yes.
And he has given me another 15 days. Second show also is para 3. Same ground, my lord. 15 days notice.
Where the 15 is shown?
My lord, therefore, yes.
Above has been held where the case aside within the nation. We're going to refer to the problem where you have been shifting a drill machine. That is a power conferred me. Where is the 15 days?
My lord, para 3, my lord. In exercise of the power conferred upon me by the opposite agreement, for on behalf of the President of India, hereby give you notice to show cause within 15 days.
Okay.
My lord, another 15 days given. Before expiry of 15 days, he has given another letter, page number 92, 24th, my lord, 24th February. And there, my lord, he has allowed me, may take my lord attention to para 3. However, on 23rd March, you have assured to complete. It should not be 23rd March, it should be 22nd February, my lord. I have assured to complete the said work in all respect, or not before 023/23 in the camper of such. And same was endorsed on the side order book, and you have requested to sign in the book as per rule, but you refuse to sign, as it is requested to complete the work as issued by you. In view of the above, you are hereby informed that if the subject work is stated, as stated above, will not be completed, then necessary action will be taken as per the terms and conditions of agreement. Hence, complete the site work at the earliest and sign on site order book as requested above. So my humble submission, my lord, the first and show cause notice is gone. Because by subsequent letter issued to me, allowing
they were washed away, you mean?
My lord, washed away, because they have given me another time. Thereafter, my lord, page number 93.
1 second. Yes.
My lord, page number 93, they have given me another extension order. My lord, may take, I take para 3 on.
Dated?
Well, dated, my lord, 9 March 23, my lord.
Yes.
It says in para 3, in view of the above, you are further requested to expedite the progress and complete the subject work at the earliest, please. So it was extended, my lord. Extended. And thereafter, may take two.
Now, what do you say that you mean to say that, Mr. that once a blacklisted is supposed to stop the contract?
My lord. Now,
that's what you mean.
My lord, they say that they have issued a blacklisting order. When they issue blacklisting order, contract they did not cancel it. Contract was still with me.
Right.
And during the pendency of this writ petition, they cancelled the contract also. Now, my lord, I did not challenge the contract or cancellation order. I agree with the impugned order, blacklisting. This has effect.
Blacklisting and and a contractual dispute are two different footings. Because maybe in a contractual dispute, you sometimes mass justice is not necessary also.
Right.
But if you are going to blacklist it as civil consequences, and then you have to be heard. That's only that is parameter by which you
yes.
My lord. Yes.
My lordship is confined to that only, my lord.
Yes.
Now, page number, may I take page number 96, my lord.
Yes.
This was issued by the authority on the 5th April. Now, with reference to your letter, it is to inform you that the claim rates which analyzes GSTPL voucher not found enclosed as per general condition of contract sunset for approval of extra substitute items beside above.
Just dated 5th April.
My lord, it is acknowledged that I performed the work, my lord, and they are ready to process the bill also. Now, the third shock order notice may come to page number 98.
Yes.
My lord, here also the same ground they have taken. This was issued on 20 April, and the para 3 again, my lord. They have given me 15 days. Quoted the clause 3A and B. Now, clause 3 and A and B consists of the 3 actions, adverse action to be taken against
That means to say, you mean to say that first show cause notice issued on, that was on 10th of January, right?
Yes.
Then you file a reply. Then the second show cause issued on 6th of February.
Right.
But meanwhile, they allowed you to continue with the
They
work.
allow me to continue.
So you're saying that once that letter, the 6223 was issued, that means the both two show cause notices are not to be considered anymore. Then
That was
after that, you mean to say that the third show cause will be like a fresh show cause
fresh
since
show
you
cause.
not complete the work, correct?
Yes.
Okay.
A fresh show cause was issued to me. They mentioned third show cause, therefore I read out third show cause. In fact, it is the fresh show cause, my lord. And fresh show cause, they have given me 15 days again. A similar ground there. My lord, this was issued on 20 April.
On?
April.
Okay, yes, 20 April.
Man.
Got it. 20th April. Okay, 1 second. On 20th April. 24, 23.
Well.
Okay, yes.
And before expiry of 15 days again, my lord, may kindly see page 100, page number 100. They have issued this another letter, 2nd May.
Yes.
Second, may I take the second paragraph?
Yes.
As you are aware that the work for installation of the deep well at gate number 5 for new constructed such, PSF Umbling, was awarded to you by the agreements and such. There was a delay in initiation of the work due to delay in geophysical investigation for boring of the deep well. However, the work started on 16 January 23, and drilling of board well was executed feet deep up to such. Thereafter, MES casting pipe was required to be lower into the bore. However, MS casting pipe such MFDI brought by you at site on Sunset was substandard and as per the required specification, and the same was replaced on Sunset, which was also found to be substandard, and again it was replaced on Sunset. You were directed to start the lowering of the pipe at the earliest, but you did not turn up and show lack of interest for its resumption of work. On Sunset, the matter was deliberated upon in the chamber of the DIG Sunset, and have given assurance to complete the assigned work in respect of or before Sunset. Now further on Sunset, a lowering machine started the work, but meanwhile casting pipe stuck in bore well Sunset due to 1 month delay lowering work for which none other than your firm is responsible. However, on humanity ground, electrical branch of this office tried to function the bore and lower
So
the...
again by this letter, they allowed you to complete the work.
They allow me to complete the work, and if I don't complete, my lord, they say they will terminate me. Para 5, lordship can see. At the bottom, keeping in view of the above, I understand take a lenient view, providing you one more opportunity to complete function bore well in all respects or 8 May, failing which agreement will be terminated. Well, so they have selected the one action under the clause 3 A and B.
Yes. Yes.
And thereafter, my lord, thereafter, page number 104, I have given my reply. I have given my reply thereafter, but I may not take my lordship time to my reply. I may straight away come to 104. But dated 17 May. 17 May. No.
Now read the reply. That's all admitting or not conceding.
My reply, my lord. But yes, sir, that's while admitting but conceding to the previous miscommunication delay by both sides regarding the unsuccessful drilling and installation of the Sunset at different sites, I humbly request you to kindly furnish me the survey site and sample approval for the present site before execution of the work so that I can start the work at the earliest. Further, it is important to mention herein that the failure to execute the previous drilling and installation of Sunset and not responding to show cause notices was not intentional or deliberate, but due unavoidable circumstances. It is further requested herein that due to the unintentional and unsuccessful execution of the previous work, I request the good office to kindly withdraw or recall the show cause notice so that my future contract are not jeopardized. I undertake to execute and complete the drilling and installation of the Sunset to the satisfaction of all authorities concerned, as and when the survey site and sample approval survey report is furnished to me. There was some misunderstanding is between the petitioner and the department. So this was his reply. Now, thereafter they have issued another notice 104, my lord. This is the last notice, issued on 17 May. And they have a, number 2, my lord, they also acknowledge that with reference to above, it is to inform you that your plea on the subject cited above not considered being devoid of merit because as per agreement, drilling up borewell is executed to be up to 1,016 feet by your firm. But drilling of the borewell was executed up to 480 feet only as adequate water level was found at 400 to 480 feet. Thereafter, the MS casting pipe was required to be lowered into the bore immediately, but we have started the lowering of the casing pipe even after lapse of 1 month. As a result, casting pipe stuck in the borewell, such. So they do, my lord, in fact, we dig, and when we dig, my lord, when the machine reached to the 480, sufficient water came out. So the inspector also came to, okay, you stop digging here, you can prepare for the supply. So it did not go down to the 1,016 feet, my lord. So they do admit this one. And thereafter, in the last...
Now this is something was stuck.
My something is stuck, my lord.
Yeah.
Para 5, my lord, the next page, my lord. Considering above, my lord, he says, you are hereby once again requested to complete function the above borewell within 15 days on receipt of this letter, failing which the agreement of work will be terminated without further delay, further notice on the subject cited. So the notice given to me was, if I don't complete, work will be terminated.
Yes.
Not the, my lord, the blacklisting. No issue, no notice was issued for blacklisting. I'll cite one Supreme Court order regarding this to persuade my lord. Thereafter, I have given my reply, page 160, but straight away, may I come to the...
106.
106 is my short reply. My lord, a similar reply I have given. And the impugned order 109, they have passed the order. So my humble submission, my lord, there was no show cause notice issued to me with regard to blacklisting, my lord. They have issued to me show cause notices number of times where subsequently they extend time again and again. And final show cause notices, if I fail to perform my contractual work within 50 days, the contract will be determined or terminated, my lord. They did not dispute this position in the affidavit, my lord, With regard to this point, my prayer here in this, my lord, before my lord is to set aside the impugned order, and number 2, to settle the pending bills, lordship may more relief, and third one is, my lord, my pipes are lying in the compound, the premises of the PSF. Number of pipes are there.
No, one thing.
And they are not allowed to take away.
Is the well functional now?
My lord, they have it was functioning. They even utilized the pipe by installing the electric by the department itself. From my side, the installation of the electricity is the duty of the authority.
No, of course. Now, but was the well functional?
It was functioning for some time, and later on, my lord, they discontinued it, and they said you did not complete the work properly, so they did not allow me in the premises. And subsequently, my lord, perhaps they have conferred the contract to other third party. We don't know, my lord. They are not allowing me to enter. Okay. And all my pipes are lying there, so I have written a letter to them, allow me to withdraw my pipes, which is not utilized.
Okay, yes.
My lord, before I go to that second issue, with regard to this, may I cite one Supreme Court judgment?
Yes.
Regarding the blacklisting.
The recent judgment of this court also regarding blacklisting.
Mild. Lordship, I have seen the Lordship order also. It is very clear. Lordship has laid down one point. Now, may I take to paragraph 24 and 25?
Not reported in the SEC.
My lord, this would be, my lord, this order was passed on 1620. Yes. It must be, my lord. I did not.
You kindly get it out. Yes.
I will, my lord.
Is it better with citations in?
Yes.
Writing all these civil appeal numbers. Yes, what is the point?
My lord, may kindly come to paragraph 24 and 25?
Yes.
May I read, my lord? A plain reading of the notice makes it clear that the action of the blacklisting was neither expressly proposed.
Where are you reading from?
My lord, may kindly running paragraph 24.
Para?
24, my lord. Of the judgment.
20. Para 24?
Para 24 of the judgment.
Internal page, how much?
But para 24.
Internal page of this.
Internal running page, my lord, is 18. At the bottom page is reflected in the, at the bottom.
Oh, yes.
18.
18?
My lord. And
para 24?
24, my lord.
There's no para 24 here.
It's different. My lord, I'm so sorry, my lord, the other copy. We just refer, my lord.
You give wrong judgment.
But it is same judgment, but different. It just, lordship. Para 24 and 25, it is very clear.
Yes. Yes. That's the only correspondence totally with regard to the culminating the blacklisting. That's all debarment rather. Nothing else.
Nothing else. Nothing else. My lord, after blacklisting order was issued, subsequently to dependency of writ petition, they have cancelled the contract and they have forfeited my.
That's subsequently. Yes. What this court also know, like that the process that was taken before blacklisting you, that is all. 3 show cause notices.
Yes.
First 1, 2 show notices, then ask you to complete again. Yes. 3rd show cause followed by complete again. Yes. Then blacklisting.
Then straight away comes to blacklisting. Okay. So now the decision I'm citing with lordship permission is it's very clear. Apex Court say that when show cause notice is issued, one must expressly mention about your intention to blacklist, so that the contractor will have the opportunity to justify his action. The civil consequences he will be aware. Now, without expressly mentioning that one, the blacklisting order is bad in law. In my case, my humble submission is that all the show cause notice issued to me, there is no intention of blacklisting.
Yes.
Well, so in view of this, my lord, the impugned order may be, my lord, interfered with. And second, my lord,
after notice makes it clear action back to the expressive proposed that could have been inferred from language employed. Yes. Yes. This one, but see, the power to blacklist has been mentioned in the show cause notice.
Yes.
But then in this judgment, even that clause was not quoted.
Quoted, and intention was not discernible. Intention to blacklisting.
But then in your show cause notice 25, you see, it's proposed. Let me show cause notice say that. Let's see your first show cause notice.
My first
is at page 89.
89, my lord. They have quoted the clause.
Yes.
And the clause comprises of the 3 actions.
Therefore, I annexed the powers conferred on me by the aforesaid agreement. For behalf of the President of India, hereby give you notice to show cause in 15 days to my satisfaction why an action under clause 3A of agreement will not take into account of breach of contract on your part. Yes. Please note that in case no cause is shown by you in stipulated period of a cause shown. Yes. So that means this judgment will not really cover you, because in the show cause notice which is referred to this judgment, they don't even refer to the clause agreement. But in this case, specifically, though you say that the show cause watered down after the subsequent letter, that's another aspect, but is mentioned. Anyway, yes.
My lord.
Next
and
judgment.
Second show cause also, my lord, the same thing. And first and second show cause gone after they extended me the time, my lord. And third show cause, which is considered as the first second fresh show cause, my lord, subsequent or notices, they asked me to complete with failing which termination. My lord. So in view of that, my lord, my humble submission is that there is no adequate opportunity being given to me with regard to show cause. The affidavit filed by the respondent, my lord. They do.
So he's citing the one decision.
One decision, my lord. And my lord, my prayer portion may invite to my lord the prayer portion. The relief I'm seeking, my lord. Page number. Page number 18 and 19 of the petition, my lord. first prayer I sought for setting aside the blacklisting order. Second is to direct the respondent to release the arrears bill on submission of the final bill by the petitioner as per.
That we can't direct.
My lord, I would point out the clause of the contract, and lordship may kindly consider regarding this point. Now, the affidavit filed by the respondent, my lord, I may take the affidavit, and the cancellation order, termination order, my lord, is page number 151.
Page number?
151 of the affidavit.
151.
151.
You filed 2 affidavits, Dr. Mozika?
My lord, they filed, in fact, I filed a rejoinder, and after rejoinder, without leave of the court, they filed another affidavit.
Reply to rejoinder?
Reply to my rejoinder, but anyway. So,
what is he, which first affidavit?
My lord may kindly come to first affidavit, the bigger affidavit. Turn to my lord, page 151. On 30th July 2023, they have determined the contract. My lord, 151.
Yes.
My lord, 151, my lord. They have determined, my lord, the first, whereas sunset, my lord, in the middle, my lord, ending of the first paragraph, I, the engineer in charge for the aforesaid work under the aforesaid agreement, for on behalf of the prisoner, when they hereby determine, my lord, determine the contract as aforesaid, upon which performance guarantee deposited by you for this work stands absolutely forfeited to the government and shall be absolutely at the disposal of the government. So by this order, they have cancelled the contract, determined the contract. Now, when they do the determination of the contract, the clause I will just point out, one, the clause which indicates that the petitioner entitled the bill after verifying by the authority. My lord, may kindly come to page number 83.
Of your petition?
Of the same affidavit.
83.
83, madam. Clause 3, when contract can be determined.
Yes.
Madam. Well, the ground they have mentioned there, I may not, my lord, take your lordship time further again. I will, my lord, straight away come to page 85. 85, my lord. Condition B, my lord. In the, my lord. After giving notice to the contractor,
85,
85, my lord. Contractor to measure up the work of...
What are you reading?
My lord, 85, B, my lord. B, my lord. After giving notice to contractor to measure up the work of the contractor and to make such a whole or the balance or part thereof as shall be executed out of his hands and to give it to another contractor to complete the work. The contractor whose contract is determined as above shall not be allowed to participate in the tendering process for the balance work, including any new items needed to complete the work. In the event of above courses being adopted by the engineer in charge, the contractor shall have no claim to compensation for any loss sustained by him by reason of his having purchased or procured any materials or entered into any engagements or made any advances to on account of or with a view to the execution of the work or the performance of the contract. And in case an action is taken under any of the provision aforesaid, the contractor shall not be entitled to recover or be paid any sum for any work thereof or actually performed under his contract unless and until the engineer in charge has certified in writing the performance of such work and the value payable in respect thereof, and he shall also be entitled to be paid to the value so certified. My lord. So my humble submission is, my lord, they have determined the contract. I have performed the work also. My humble prayer, my lord, allow me to submit the bill and let the engineer in charge verify the correctness of my claim, and he may pass the order for recovery of amount which I entitled, my lord. That is my second prayer, my lord. Because the contract paper itself allow me. My lord. And the last prayer may I pray, my lord.
Yes.
In my rejoinder, my lord. My lord may come to my rejoinder for a while. My lord, in para 27 of my rejoinder, or the 37 of the rejoinder, I've highlighted the materials that are lying within the premise of the authorities Page number, my lord, 15. Page 15, paragraph 37. I've highlighted.
Yes.
And my lord, these are the articles. And I do, my lord, brought before my lord notice by including the photos, my lord. I invite my lordship attention to page number 22 of the annexure, my lord. I put up a letter, formal letter to the authorities.
I don't think whether you can sue for damages. I don't think this blacklisting, like Mr. Chaniso, will be a different aspect altogether. Now, if you're looking for a contract that's gone bad, or that you have any claims arising out of the general terms or conditions of a contract now, if you feel that yes, the action will be taken under the agreement and you have completed your part, maybe there might be a breach, and any residual benefits or consequential events that have happened, which you feel you entitled some relief, that the Red Court cannot give you, because that comes under disputed facts again. But what is the extent of work you have completed, whether those pipes are lying there?
Yes.
So that we will not touch upon. Just remember that this court will limit itself only to seeing whether the action of the respondents and blacklisting you is arbitrary. We'll confine it to that.
That is one aspect. Regarding the other
one, I think you're free to sue for damages. You have recourse to civil, and it is in the realm of civil law remedy only.
Those are disputed since the
private law remedy rather.
Only if lordship give that observation. Only that.
Of course, that will have to come, because you cannot be deprived of any way to release or to seek remedy. So that we private law, public law will come with the action of the respondents is arbitrary, unreasonable, malified. Those are the things which will invite interference sitting in Red Court. That's the only thing. So we confine ourselves to that, just to examine the actions of the respondents, whether it's arbitrary to such extent that yes,
but that
it is bad in law.
That is a major issue. Major issue. With regard to other one, if lordship
the other one will not touch it, because even if you touch it,
my lord,
it will not come to any.
My lord, in case if lordship allow me to come up with a bill, and the engineer will verify, and if I'm not satisfied, then I can go to civil court. But
unless it's certified or admitted, then you can't seek mandamus for payment. Yes.
If lordship will open that window only, allow me to come up with a bill, so that the engineer will verify. And subsequent order of the engineer, if not satisfied, I have no option but to go to
that you can file a fresh writ.
Appropriate authorities.
You can file a fresh writ if the bill is certified.
I
You present the bills before the authorities. If they don't have any dispute and you don't pay it, then yes.
But that I have to resort to other position, madam.
Yes.
Now, only about this page 22 of the rejoinder, my lord. I put up this letter allowing me to withdraw the remaining materials lying there. My lord, lordship, kindly take the pain to see page number 22 of my rejoinder.
This page 18 was water's coming from where? This water, crystal clear water is flowing. Page 8, annexure 1.
My lord, this is the one I have constructed.
It's from your well.
Yes,
second paragraph.
This is the one I have done. In fact, they are utilizing it, but since they dispute, I cannot press. They say it is not, so
what's the question is this person holding up?
That's not correct, is it? The drilling he has done is totally collapsed.
That is what
disputed one. But so page number 22. This is my letter, and the materials lying, my lord, photograph, my lord, can see. Page number 24 onwards. The number of pipes are lying there.
So whose pump is this one at page 19?
But
your pump.
It is mine. I brought
your pump.
I brought my lord under the contract. It is lying there. It is lying there. But I'm praying for my lord the materials that is lying from page number 24 onwards. Allow me to withdraw. Now they have filed another affidavit by the DIG regarding this issue. They are ready to issue, my lord. Lordship, can you see their affidavit? The last affidavit filed by
PHE?
By the DIG, my lord.
Oh, DIG.
DIG, my lord. My lord, can you see
these pipes are 24, 25. Whose pipes are these?
It is my pipe. I brought.
Don't see your name written on it. Just in jest. Yes.
And my lord, with regard to this one, the last affidavit filed by the respondent.
Return the pipes to him.
My lord, they are ready, my lord. May I just read out the relevant paragraph which they are ready. My lord, paragraph 32 of the affidavit.
Para 32?
32, my lord. My lord, it is that, my lord. With regard to the statement made in para 237 and 38 of the rejoinder affidavit, it is submitted that petitioner violated the sunset has asked the permission.
Yes.
Yes. So, my lord, they are ready to release, but they could not because of dependency of the petition. Civil lordship direct them to release. My lord. So, this is my humble submission, my lord.
Yes.
But here, my friend is submitted, my lord. The drilling was required to be done for 1,037 feet, my lord.
1,000?
37, 1,017 feet, my lord.
Yes.
Now, what happened, my lord? While drilling at 480 feet about, the water came out, my lord. So the drilling has to stop there. Now, what was required that he puts in the pipes, my lord.
Yes.
Now, he brought a pipe which were absolutely substandard quality, my lord.
Okay.
So, the respondent told him that these pipes are not as per the specification, you have to bring fresh pipes and you replace.
But in the contract, there's no specification of ICI pipes or no specification.
Well, I'll try to point that out, my lord. But in the affidavit, we have said that this is not as per the specification provided in the contract, my lord.
Yes.
Now,
you mean they're totally unusable?
My lord, he stopped the work, my lord. Then after several requests, after first notice, second notice, he brought replacement pipes, my lord. Now, in the meantime, because when the drilling is done, my lord, this is a 5-inch drilling going deep of 400. The pipes have to be inserted immediately, my lord. Now, what he does, my lord, he waits for almost 27th January, he did the drilling, my lord, and 28th of February. It was almost a month's time. By that time, the drilling has collapsed from within, my lord. So when we was trying to insert the pipe is not going after 230 feet, my lord. So that has rendered the entire exercise useless, my lord. And that was the reason we had to take action against him. Because right from the beginning, your lordship noticed, my lord, he is not interested in executing the work as per the specification given to him, my lord. I'll just point out few paragraphs in the affidavit, my lord.
The only thing is that, see, Dr. Mazika, we're like repeating again, limiting this examination only to whether the sequence of events that happened, the sequence of letters, that is your first, second, third show cause. You give your first show cause, which it's in the mind of the court. First show cause you give, it should the logical progression is that you go towards blacklisting something. Not you give first show cause, and then you concede, you give concession to him, complete the work. You give second show cause, again you say, okay, fine, complete the work.
Well, we are lenient.
After giving reply, the third show cause you give him, again you say complete the work. I mean, is that a proceeding, that they can culminate in a blacklisting?
My humble lenience should not be taken as weakness, my lord, because we are lenient to him. He should be obliged to us for that, my lord. That we are lenient, giving him chance time and again, my lord. Please come and complete the work. Please come and complete. Ultimately, my lord, I had to come back to your lordship, my lord, for some interim orders. Because we are facing the acute shortage of water, my lord, and then I filed an order of 23rd May 24, my lord. Lordship,
in the order sheet?
My lord.
23rd?
23rd May, my lord.
Yes.
The instant matter concerns the installation of the deep tube well in the premises of the respondent BSF at Umpling, Shillong, wherein the petitioner contractor on being debarred has approached this court. It is noted that there are no orders operating whereby there is any restraint on the respondent to re-tender the said work. However, Dr. So-and-so has submitted that due to pendency of this instant writ, the respondent authorities have not gone ahead or re-tendered the work of drilling the deep tube well Mr. So-and-so, learned senior counsel for the petition, also concedes to the submission and submit that there are no interim orders operating and there are only grievance of the writ petition against the department which he contends amounts to blacklisting. In view of the matter, no orders are necessary at this stage. In fact, my lord, we came before this honourable court seeking leave to retender the matter, my lord. And this honourable court observed that there is no stay order, meaning thereby, my lord, that we can go ahead. But after this, but the current status, well, whether it has been retendered, the work has been awarded to someone else, and whether the new contractor has utilized any portion of his drilling.
Has it been retendered?
My lord, on that my lord, your lordship takes up the matter tomorrow. I can call up the officers also. My lord.
But only on that point, you see, because
and whether his pipes are still lying.
The only thing the court is to examine is whether leniency or weakness, or that is not the concern of the court.
My lord.
There's no question of sympathy. The only thing is that to see whether your decision-making process is appreciated or not. That's all.
And my lord, another ground that we have taken.
Tomorrow is the last day of working day.
Tomorrow is Thursday.
Friday is a holiday, man. Tomorrow, only tomorrow.
Friday is holiday.
Friday's holiday is Wangala festival.
Or Monday.
Yes.
One ground what we have taken, my lord. We have only.
First, come prepared to show that there is reasonableness in the action. That's all. He is not, visited by, is not arbitrary. That's all. Leniency, yes, but then whether it will, what do you call it? The actions are so such that blacklisting will be.
My lord, the plea we have taken, my lord, because BSF does not list. We don't maintain any list of contractors, my lord. So we simply refer to CPWD enlisted contractors or other departments, my lord. So we don't have, because we don't list anyone, my lord, we don't have the power to blacklist also. So
no, debarring is another form of blacklisting.
And debarring only for a limited period, and that also only with BSF, my lord. We have not debarred him from
they are circulating to all the departments.
Contracting with
all
any.
Because of that,
any
all the departments.
Mr. Chancellor, why you have not worked diligently after you've been settled a contract?
My lord.
Why your client didn't work diligently?
My lord,
he's too busy.
My lord, the survey has to come from Guwahati, from the groundwater board.
No, forget about the handing over the site. That question of delay is not a question here. The only thing is that they think about the quality of your work.
But that is a dispute, my lord. They
exactly, that's why disputed. This court can't go there.
But my lord, that is
we only look at whether
the procedure only. Lordship only examined the procedure.
In the course of hearing Dr. N. Mozika, while replying submissions made by learned senior counsel petitioner, praised it out some time to obtain instructions as whether the said work has since been retendered and or completed. This is matter on Monday, that is 11th. As we thought of disposing of in the court itself anyway. But we've heard you, we won't need to. Yes.
36.
Because whether his pipes are still there or not, that also is a factual aspect.
Or the pipes have been happily.
Yeah, only if it says it is.
But the pipes are so bad, man, they must have become powder by now.
You never suppose your new contractor use those pipes and save money for himself. Yes.
36.
Yes, Mr. P.G. Sama.
Yes, my please, Lordship. This is actually this is a contract matter for non-payment of bill. Now here what happened? They are finally rejoined. Now they are not disputing the work which I have done. They said they are admitting the work. There is no dispute with regards to the completion of the work. Now since only the dispute is only the amount, so they are offering at least that 10 lakh, that according to their conclusion, they said 10 lakh plus, that is my due. So I have discussed with the petitioner also. The petitioner also is willing to accept the 10 lakh, and but with the liberty to pursue some other remedy. The remaining outstanding amount, we are claiming more than 10 lakh actually, but they said the amount which I'm yet to pay is that according to them there's only 10 lakh plus. That money in the para 6.
What was the value of the project?
The value of the project is actually it's amount 96 lakh, my lord.
Where is that? Let's see.
Yes, Lordship.
Where is the bill certified? sanction order dated so and so.
There is a page. My repetition annexure 1. This is the amount, total tender value.
Yes, okay.
89.
Right, then I'm trying to connect sanction council to revise estimate of source of concentration. So, okay, fine. You see, under annexure 2, you completed the balance work.
Yes, this is the, and they have written also that successfully carry out the work.
Yes, okay.
This type of construction.
Now, how much have you been paid?
They are saying that some amount had been paid to me, but then I have not received. Whatever may be now, since they are giving the 10 lakh, so we will take that money with the liberty that, yes.
You're only asking for the remaining 15%, but that's usually held back by the government always, in all contracts. They don't release the entire amount. You know that? Suppose you finish contract 100 rupees, they'll give you 85 rupees. Just 15 rupees they'll keep back to see whether, that the work's all right or not. Yes. So you've already been paid, see, from total amount 80 lakhs 55,000, 85% has been paid. That means?
As per our calculation, it comes to 68 lakhs 47,319.
68 lakhs?
47,319. If he claims it is 85%.
319.
Lordship.
And you wouldn't give him 10 lakhs more?
Lordship.
What's the less?
No, what he's claiming now, that he has done extra work on a mutual agreement with the department. So therefore, there is a revised bill. Now, can you see that revised bill, my lord? If Lordship will have my affidavit, yes, it comes to 99 lakhs. But we've explained what this revised bill relates to. Because the work was in two parts. He was allotted the construction, the civil works. And somebody else, some other contractor was allotted the electrical works. So the petitioner has misunderstood this bill. If your Lordships will have page 20.
Balance for construction, page 13.
20, annexure 6. So this is the comparative statement of the two sets of works, my lord. In the first column, Lordships will see serial number A is civil works, which is highlighted.
Yeah.
And towards the bottom, Lordships will see what is the total for that work. That is 83 lakhs 33,175. So this is what he's entitled to. Of this, 85% has been paid. The remainder, as soon as the sanction is done, as per the contractual terms, that will be released to him. Now below that, what is highlighted is in that first column, electrical works. This was allotted to a different contractor. So that brings the total to 99 lakhs 42,288. So this work is for about 6 lakhs for 74,000. So my friend wants to claim the entire amount, although he's not done any of the electrical works. That's how he's reaching this figure of 99 lakhs.
So you take the 10 lakhs and be
yes,
happy.
Lordship. Yes, but only maybe some remedy, just not maybe just if you want to file a civil suit.
Just what remedy? You tell the court what the things still have not been given to you.
No, we will take that 10 lakh, but at least for his satisfaction, maybe given liberty to pursue some other remedy like to the petitioner, because sometimes he may think that I have blocked the entire thing after taking it, because
that you have.
The petitioner may think that I have.
The lawyer has done something.
No. Then? My only I'm not insisting, but only submission is that we'll take the 10 lakh rupees, but with the liberty to pursue some other remedies like this, some sign of observation with that one. So I think they will not have any objection to that. Means like he may like to file a civil suit if he suppose claiming not satisfied or that because if he disposed with the 10 lakh, then
see you can't have you take it, otherwise you will decide the matter on merits.
We'll take it, Lordship.
Yes. Where's the affidavit where you going to
para 6, my lord.
My affidavit, which is at para 5, page 2 onwards.
That relevant.
Para 5.
Para 5 in my affidavit, my lord.
No, that means that the earlier contractor died.
Yes, my lord.
Then he stepped no shoes.
Yes.
I did work with 48 lakhs, that means.
No,
Paragraph 5.
No, as per the instruction, actually, I'm not claiming what he said that he have done it the entire thing because my repetition, whatever maybe lordship, I'm not going to argue on that since.
Just read this paragraph 5.
Let me read, my lord.
Just
Para
read
5.
read it.
That with regard to the averments made in para 2 of the writ petition, the answering deponent states that a tender was floated for the construction of double-storied office building for Executive Engineer WR and Subdivisional Officer William Nagar for an amount of 60,76,500. White NIT dated 23/5/2008. Subsequently, the said work was allotted to one Sri Prabin Mara, Class 1 contractor, wide work order dated 21/4/2009 at 10% of the 10% above MPWD schedule of rates for the building works for so-and-so circle for the year 2004-5. It is further stated that due to the health of the said contractor prior to the death of the said contractor prior to the completion of work, a second tender was floated for balance work for construction of double-storied office building at so-and-so. Wide NIT dated 23/2/2012. It is pertinent to mention herein that the second tender.
He responded to this in 90 days.
Yes, my lord.
Okay.
Second tender was floated for civil works, excluding electrical works, for an amount of 48,82,000 so and so. Successively, the work was allotted to the petitioner wide work order dated 23/2012 at 65% above the original amount. That is, tender value amounts to 80,55,670. In addition to the above, it is relevant to state herein that another tender was floated by NIT dated 26/6/2014 for internal electrification of the office building of so and so for an amount of 4,96,650. The said work was allotted to Messrs. Purabi Electricals, William Nagar, at the rate of 30% above MPW schedule of rates. Kindly see para 6. That with regard to the averments made in para 3 to 7 of the writ petitioner, the answering representative states that the petitioner completed the work in 2008, in which a completion certificate dated so and so was issued to him by the office of the executive engineer. Thereafter, a revised estimate amounting to 99,42,000 was sanctioned by letter dated 16/10/2020. It is pertinent to mention herein that the said revised estimate amount is inclusive of civil as well as electrical works and also the works which was done prior to the allotment of the work to the petitioner. Moreover, an amount of rupees 70,24,800 only, which is 87.20% of the cost of the balance civil work, has already been paid to the petitioner. Hence, the liability at present to the petitioner is 10,30,870, which is only 12.80% of the original amount. So that is what is outstanding.
So, Lordship, we will accept this. We will accept this 10 lakh.
No interest.
Will not claim, sir.
You're not claim. Okay. This writ application, the writ petitioner had come before this court with a prayer for release of the amount spending for works which he had successfully executed. That is the balance work of the building of the executive engineer bracket WR East Garo Hills Division, William Nagar. Stop. Next paragraph. Mr. P.T. Sangma, the reconciled petitioner, has submitted that the writ petitioner on the affidavit filed by the respondent, wherein it is stated that the amount outstanding is rupees 10 lakhs 10 comma 30 comma 870 only, is prepared to accept the same and put a closure to the entire matter. Ms. S.N. Counsel Petitioner.
Respondent,
sorry, concurs submission and has taken this court to para 5 and 6 of the affidavit filed on behalf of respondents, which details the manner in which the work was allotted and also the amounts that were since released to the petitioner. I've heard the counsel of the parties. It appears from the averments made in the writ petition and in the affidavit that the writ petitioner was settled with work which was floated by a second tender for the remaining works of the office of the executive engineer, and that on completion thereof (87.20% of the cost of the balance civil works had been paid to petitioner. It is noted that as submitted, the liability at present is 10,30,870. In view of the submissions and averments made by the parties and on affidavit, this petition is disposed of with a direction that the petitioner be paid the said amount of rupees 10,30,870. That is 10,30,870 by the respondents within a period of
6 months, Lord?
6
Because
months.
it's awaiting sanction.
Period of 4 months from the date of this.
Lordship.
Yes. Common as ordered above, matter stands closed to disposal. Yes.
Obligement.
38.
Much pleasure, Lordship.
Please, Lordship. Lordship, by way of this civil petition, we are challenging the order passed by the learned judge of District Council, wherein the judge has permitted the leading of additional evidence, my Lord, in an appeal.
Additional evidence meaning?
My Lord, there's a provision under Order 41, Rule 27, which allows an appellate court under certain circumstances, my Lord, to permit either parties to file additional evidence, to lead additional evidence in the appellate stage. Our contention in this case, my Lord, is that there's an error, considering the fact that the respondent herein have sought permission to lead additional evidence on issues which they have not agitated before the appellate court, my Lord.
But what about a trial court? Was issues there?
Yes, my Lord.
They were there.
Yes, my Lord.
But then now when the matters were examined, were issues framed?
No, my Lord, the respondent herein were the plaintiff in the original suit.
They were the plaintiffs?
Yes, my Lord. I am the defendant. The suit was dismissed. After that, they filed an appeal, my Lord. In total, there were 14 issues that were framed by the trial court. Now, my Lord, the main issues were around 7-8 main issues, my Lord. So when this appeal was filed before the appellate court, the main contention of the plaintiff, who's the respondent herein, was on those main issues, my Lord. So now, when the even in their pleadings, my Lord, they have never touched on that, on those minor issues. Now they have filed an application seeking permission to read additional evidence on an issue which they have not even agitated in their appeal
Then
petition.
not framed issue, then the courts answer on issues. How would the judgment be rendered then?
No, because
Unless remanded to the back to the trial court for for retrial on certain issues which they feel is relevant. Let's see the order.
Yes, my lord.
It involves property or
Involves forest land, pine groves.
Yes.
My lord, the impugn order is in page 111, my lord. And the reasoning given by the learned judge, my lord, is on page 115.
Page
115. The third paragraph, my lord.
Why is it typed like this? This order in one column 3. Is the print so small?
I don't know, my lord.
Yes.
Yes, my lord. The third paragraph, my lord. Says,
Yes.
Having heard the learned counsel for the parties and on perusal of the record of the case in hand is that the applicant filed the application under Order 41 Rule 27 of the court when both parties have filed a written argument and the matter was fixed for oral hearing on the ground that the applicant obtained the boundary map issued by so-and-so regarding the land jurisdiction and boundary of Elaka Muso and the adjoining Elaka after decision was rendered by the trial court. In regard to the aforesaid issues, the learned trial court examined the evidence of plaintiff and 2 other witnesses and the defendant and 2 other witnesses. The plaintiff was examined as PW2, who deposed that her mother is in possession of the suit property situated within Elaka Muso. Further stated as far as she knew, the lawyer of both the Elaka has already inspected the territorial jurisdiction, and as far as she knew, the lawyer confirmed that the suit property is situated within Elaka Muso. The plaintiff executed a sale deed exhibit 1. In cross-examination, she stated that she do not have any document to prove that both the lawyer had confirmed that the suit property is situated within Elaka Muso. That it is not a fact that both the lawyer has not confirmed that the suit property is located within Elaka Muso. That she do not know that the lawyer of Elaka Nongjingi wrote a letter to the lawyer of Muso that the suit property falls within Elaka Nongjingi. PW1 deposed that the suit property is situated within the boundaries of Elaka Muso, and the claim of defendants that it is within Elaka Nongjingi is false. Further stated, the village was divided into
between villages.
Private. The plaintiff, Your Honor, who's the respondent here, is a private party, my lord.
She says that she belongs to Minso.
Yeah, her contention, my lord, before the trial court is that this suit property falls under one Elaka, that's Elaka Muso. Our contention is that this particular property is in Elaka Nongjingi.
You're for the Darbar?
Yes, my lord.
Okay, yes.
Falls within Elaka Musko and half of it falls within Elaka Nongjingi. The suit
This
property
village in 2 parts. First said the village in 2 parts, half the village. Is it correct?
My lord, that's what they are saying, my lord, but that's not our contention, my lord. We are saying that it's before the Elaka Nongjingi only.
Now, where's the questions for evidence?
So, my lord, if I may read, my lord, this is the reasoning given by the...
Okay.
Yes. The suit property falls within Elaka Muso. In cross-examination, stated it's not a fact that the suit property falls within Elaka Nongjingi. PW3 stated that the suit land is called Umsuwer falls under Elaka Muso, and further stated that since the suit land falls under Elaka Muso and the defendants are of Elaka Nongjingi, the defendants have no right over the suit land. He knows that the suit land falls within the Elaka Muso since the lawyer of Elaka so-and-so and the lawyer of so-and-so, whose names he do not know, has demarcated the boundaries between the 2 Elakas, and that the suit land in view of demarcation falls within Elaka Muso. In cross-examination stated he do not remember the year when the lawyer Muso and the lawyer of Elaka Nongjingi had demarcated the boundaries of 2 Elaka, and that he do not have any documents to prove that the 2 lawyers had demarcated their respective Elaka. My lord, subsequently the trial judge or the appellate judge have reproduced the evidence, my lord. So the her finding, my lord, is my lord will see in page 117, my lord, in the second last paragraph, my lord, she says, Order 41, Rule 27. Yes. Order 41, Rule 27 of the Code is a provision which enables the party to file additional evidence at the appellate stage. If the party to appeal is able to satisfy the appellate court that there is justifiable reason for not filing such evidence at the trial stage, and that additional evidence is relevant and material for deciding the rights of the parties, which are the subject matter of the suit, the court shall allow the party to file such evidence. The appellate court may permit additional evidence only and only if the conditions laid down on this rule are found to exist. From perusal of the evidence of the plaintiff and her witness, they stated that the suit land falls under Alaka Manso, since the law of Alaka Manso and the law of Najri had demarcated the boundaries of the two Alakas, but do not have documentary evidence to prove that the suit property falls within Alaka Manso. The defendants and the witnesses stated that the suit property falls within Alaka Najri, but do not have any document to show that the suit property is the forest land registered within the Alaka Najri. However, they relied on the letter which was written by the law of the law of Nongji Alaka to the law of.
Yes, one thing. Sorry, Mr. Shila, to interrupt.
Yes,
but the thing is that, see, the thing, this, the request or the prayer for additional evidence was because of subsequent events that happened, correct?
Yes, my lord.
And then was this an issue in a trial court regarding whether the forest falls within Ilaka Minso or no?
Yes, my lord. That is issue number 2.
This comes up from that issue only.
No, my
but
lord.
the thing is that now you say that it is wrong for a reason to ask for additional evidence. Power is there. You can remand it back to the trial court to But only thing is that the suit's already been decreed, correct?
Yes, my lord.
Where's the judgment decree?
Judgment was decreed on.
Have the records come?
No, my lord.
Why records not called?
It's never called, my lord. Because it's a limited issue only on this aspect, my lord.
Even then, no. Regarding where's the decree, judgment of the trial
the
court?
order we have annexed it, my lord. It's annexure 5, page.
Because see, it's a subsequent issue that has come, but it is might be. It'll work against your favor because they are seeking to introduce a new map now.
Yes, my lord.
But I see that you can only veracity of is only after it's done it as fresh evidence, and you say that this map cannot be relied upon.
Perhaps.
What reason? What reason? Because it was from the records I can see just now in this order that was map prepared after judgment decree had been passed.
Yes, my lord.
So they seek to introduce it. So on that ground, you have a ground to say that it cannot be accepted.
Yes, my lord.
Maybe it was prepared for the purpose of this case. You don't know.
Exactly, my lord. That is one ground, my lord. And another issue also, my lord, is that when the appeal was filed, my lord, when the appeal was filed by the respondent, in their appeal petition, my lord, there's not even a whisper that they were aggrieved by the finding of trial court with regard to this issue.
Right. No, they're appealing substantially against the judgment decree, correct?
Yes, against other issues.
This is a subsequent fact that came out because it came to knowledge. There was a survey done by GHDC, and in the survey it shows the forest falls within Ilaka Minso. So for them, naturally, they'll want to reduce that piece of evidence.
Yes, my lord. But for that, my lord, in my humble and respectful submission, my lord, first and foremost, there has to be a pleading in their appeal that they are aggrieved by the finding as to.
When is the appeal filed?
Appeal was filed, my lord, on.
Your Lordship, on the 30th, Your Lordship, 30th 10.
Of which year?
2017.
Appeal filed 30th 10/2017.
No, my lord, as per the certificate which they have annexed in the appeal petition, it's somewhere in December 2017, my lord.
They filed an appeal?
Yes, my lord.
Then when was the map prepared?
There's no date, my lord, regarding
Your
the
Lordship,
map.
the map was prepared after during the pendency of the appeal, Your Lordship.
So how could they bring it? How could they bring a record in the appeal? How would they make a pleading if that map then exists?
No, my lord, they should have at least said that they are aggrieved by this issue.
Have you challenged the veracity of the where's your did you file some sort of objection?
Yes, my lord.
Where's that? Why do you state the objection?
My lord, I'll beg to apologize, my lord. It appears that it's not annexed here, my lord.
Why?
Due to some...
You have to go on your
evidence.
pleadings only, Mr.
Yes, my lord. But I'll bring it by way of affidavit. my
I'll
lord.
be with affidavit. Is the objections are there on record before the trial, before the appellate court?
Perhaps, my lord. Because in the order, it's reflected, our objections reflected, my lord.
Fine, but then it should be on record. If you see that all the... you take down in the course of hearing. We'll have to see. Yes, sir, in the course of hearing. Have you annexed that now in the application? You've annexed, you put in that map also.
Yes,
Where's that? It's here.
It's here, my lord. It's page...
It's
page
undated.
110.
Page 110, Your Lordship.
110.
110.
There's nothing mentioning about the author of this map, nor the date is mentioned, my lord.
Your Lordship, this map was issued by the GHEDC, Your Lordship.
Whatever it is. Yes, 44 May. Yes, in the course of hearing, it appears that the records of, what is this case?
This is DC.
It's been stuck at that level. At the
Your Lordship, if you come to section 3,
There's a stay
Your
order.
Lordship.
Yes, my lord.
When was the revision preferred?
Preferred, my lord.
The order was passed on
7/5/2024, my lord.
Okay. Yes, after hearing, at some length appears that the records of misapplication number 8 of 2022, which are with the Judges Council Code Joy and necessary for proper education in the matter.
No, they have reverted the records to the, I think, to the trial court, my lord, presiding officer.
Why?
No, it's before W.S. Gayeng.
Before you filed the case.
No, because after this order was passed, my lord, in the order they have directed the presiding officer to record evidence, my lord.
It appears that the which 20 Ongbiang, sorry. Wherein the impugned order dated 2020 02 new has been passed and necessary for proper adjudication. The same requisition from the District Council Registry. Yes. Within matter listed soon receipt of records.
My lord, the interim order to continue, my lord.
Interim order, please. Should raise a next objection because that will be your basis of your
39.
Objection.
Yes. Yes, Mr. Guru.
Please, Your Lordship, the conducting counsel, Mr. H. Kawalang, is not keeping well, my lord.
Is it feeling well?
Not keeping well, my lord.
Yes, as the kind of councils are present, we have to respond this matter after. When they coming back? 2 weeks, yes.
Deeply obliged.
Second call. Item number 2.
How long Mr. Paul take?
It will take a bit of time and we can have it at 2 o'clock, subject to Lordship.
Yes, Mr. Pandey.
I believe I had a chat with Mr. Paul because it will take some time. I was told that both the parties are agreeable if the matter could be taken up on some other date. Mr. Paul is here.
Mr. Paul, you can complete the arguments in 15 minutes, I think.
This will take a little bit of a time, Millets, because my learned friend has placed certain judgments, Millets. I'll have to get past that. Because his objection is basically on 4 counts, Millets, so I would have to deal with that.
Okay, I'll just record after hearing at some length that the matter is a matter for further hearing on.
But it's after 2 weeks, Millets, would that be convenient?
Okay, 2 weeks. You take it.
What we'll try and do is, my lords, I'll try and make a compilation.
No, argue it is better because for appreciation also. Sometimes when a compilation, I tell you very frankly, I don't like written arguments on.
But
because the thing is that, it
becomes too cumbersome.
Yeah, because once you have an argument, you have to read them. So, so that, if I make my own
No, I'll just make a
sometimes,
compilation.
after it goes and it slips your mind, then
it becomes more difficult.
Otherwise,
I'll make a compilation of the judgments, my lords, so that we can refer to that while you're watching. I'll supply a copy to my friend also, so it'll be a little easier for all of us.
Good, right.